we're going to get started with the general meeting for the BMCA. So we just need to do some administrative tasks before we get started with the docket. First thing is you have a calendar in the left side pocket of your binder, which is our hearings for next year. Generally speaking, we have hearings on the first and third Tuesdays of the month. We have to schedule around CHAP, which uses this room on the second Tuesday of the month. January, though, is a little bit of an outlier. We're doing third and fifth instead of first and third for obvious reasons. I don't think we'll be ready to have zoning hearings on January 2nd. So that does mean, though, that the 30th and the 6th bump up against each other. So they're 2 weeks in a row. So just keep an eye on that. If you board members are going to be gone for any of these days, please let me know and I'll schedule an alternate to be available for that day. We're going to try to schedule 5 board members for every hearing, just in case someone gets sick at the last minute. Obviously, we can hold hearings with 4, but 5 is better. Okay, moving along, let's do draft resolutions first. So that will be under tab 5, I believe, in your binder. I'm not going to ask for edits on each and every one like I have in the past. I'm just going to describe the resolution, and then at the end I'll ask you to adopt them as a whole, or if you have edits for me, please stop me as we go, and we'll deal with it. So first one, 2023-22, 2907 West Belvedere Avenue. This was a request to use a premises as a retail goods establishment, basically a convenience store on the first floor, requiring conditional use approval under the neighborhood commercial standards, under the neighborhood commercial section of the code. That was granted, subject to a condition that was suggested by planning. Going to move on. 2023-177 900 Cater Avenue. This was a request to use the premises as a residential care facility for 17 or more residents, which required conditional use approval. The board approved that conditional use request and also considered the existing density as existing non-conforming density, because the property was used as a multifamily dwelling and then was used as a residential care facility with essentially the same density. So that board approved it under 2 conditions: that residents not be permitted to have personal vehicles and compliance with the sanitation code. Like I said, stop me if you have any questions or anything like that. Make sure to turn your microphone on. We do have Charm TV here that is recording. 2023-182, 1642 Beeson Street. This was a request to use the premises as an office and also required an off-street parking variance, which was heard together with the following case, 2023-183, 1644 Beeson Street, which was a request to use the premises as retail goods and office, requiring conditional use and an off-street parking variance. Both of those were approved by the board. And then 2023-190, 704 North Gilmore Street. This was a request basically for a residential conversion, which the board is not entitled to do anymore under the quote-unquote new zoning code. So it's a request to convert a single-family dwelling to a multifamily dwelling. The board denied this request and directed this person to their city council person. And then 1935 West North Avenue, 2023-196. This was a request to use the premises as a multifamily dwelling with 3 dwelling units, requiring confirmation of non-conforming density. So this request was approved because the board found that the last legal use was for a multifamily dwelling with 3 dwelling units. So any thoughts on any of those resolutions, or would you like to adopt them?
I have no questions. I'm fine with them.
No questions.
No question.
No questions. I'm going to vote yes to adopt.
I'm a yes.
Yeah, yes.
I'm a yes.
Great, thank you. So those are all adopted. Moving on. Let's see. So let's keep with the miscellaneous ones for right now. So just for everyone's information, there are a bunch of cases. We're trying to do some end-of-year organizing. There's a lot of cases that have just been sitting there since before I started working for BMZA. Some of them have 2021 case numbers. And so we went through and kind of categorized them all into cases that we wanted the board to dismiss and some that we wanted to follow up with the applicant on or that were still active in some way. So this list that you have, this is in the back pocket of your binder. It looks like this, it's an Excel spreadsheet. This list that you have is all the cases where we haven't heard from the applicant in over a year. They were supposed to give us something, or they're supposed to follow up and schedule a hearing, we haven't heard from them. So my thought, because our rules don't really address this situation, but only the board can dismiss a case, we can't do that as staff members. I just received this notification of contemplated dismissal for a case at the circuit court where someone had appealed to the circuit court and then just never followed up or filed anything. And I was going to just kind of change the wording on this and send this out to all of these applicants and say, this proceeding will be dismissed 30 days after you receive this notice unless prior to that time a written motion showing good cause to defer the entry of dismissal is filed. So that, we do give people an opportunity if there's some reason that they haven't reached out to us in a year, that they can keep it open. But if not, then we'll just dismiss it administratively. Does that make sense to everyone?
Yes.
That's fine, it's fair. As long as we're not precluded, we can't assess costs, I take it.
No, unfortunately not. That would be great. Okay. Any other thoughts on that?
No.
Okay, so I'm just taking that as a unanimous vote for me to do that. So I'll send out letters to all of those pending appeals so we can get some of them dismissed. And when we update our rules, we will include something a little bit firmer on that. Okay. Let's see here. Draft resolution. All right, the other miscellaneous item is that we had a request for reconsideration in 2018-150, which was originally, this was 1823 Lancaster Street. Caroline Hecker, you all remember this one, those of you who were here for that. So there was a motion for reconsideration of the board's decision, which was timely filed. We put it on the general meeting for today. In the meantime, an appeal was filed to the circuit court from the adjacent property owner. So based on, we had a prior case where there was a pending reconsideration and then a petition for judicial review. And in that case, the judge was very emphatic that once a petition for judicial review has been filed, that the board doesn't have jurisdiction anymore to reconsider the case, to have another hearing, to amend its resolution. And so in that case, the court, was very, very clear about that. So what we've been kind of in discussions about this, what we've been thinking about doing is just to hold the motion for reconsideration. It was timely filed. If we need to address it in the future, let's say the appeal gets dismissed, for example, hypothetically, the board could still hear it at that time. But our direction has been that if an appeal has been filed, then the reconsideration is kind of just, we can't hear it, basically. So happy to hear any thoughts from the board on that.
Take that as the legal advice we're getting from the law department, that we've been divested of jurisdiction to hear it if the notice of appeal has been filed. We may not understand why the person who won is appealing, and that appeal may be short-lived and might get dismissed very quickly, sua sponte. But I guess based on the precedent and I guess what the applicable rule is, the jurisdictional rule, if an appeal's been filed, we don't have jurisdiction to entertain any matters in the case. And so I agree that we should table the motion of reconsideration, not rule on it, not take it up, because we don't have the power to. And in the likely event when it's dismissed, then it would be right for us to hear. So I think that's how we probably ought to proceed. And in the meantime, I think the deck is still up, I guess.
From my understanding, it is.
The appellant who won, seeking to have it torn down, is sort of delaying that process, so nothing, I think the status quo is going to be maintained, and we'll just kick the can down the road a little bit longer, and the appellant can hold the holiday party on the deck this year. So I think we'll just leave it where it is and take it up when we hear back from the court on the disposition of the appeal. About that.
Anybody
That's
else
my
have any
recommendation.
thoughts?
I don't think there's any kind of precedent on how long we can hold it.
Well, only so long as the court, the appellate court or circuit court maintains jurisdiction.
Yeah, we're out of it, but I'm
Yeah.
saying, once it's dismissed, is there a time frame that we have to adhere to?
No, so there's a time frame from when we issue the resolution to when the motion has to be filed. But there isn't a time frame on our end about how long we're allowed to hold on to it.
Yeah.
Generally speaking, we try to get it, we would have tried to do it today, but if it had not been for the appeal. And it just, there may be questions about standing and that sort of thing, but I really don't want to get in the way of the circuit court determining those kinds of outcomes.
I can understand it. We're in the freeze mode.
Do you have any thoughts, Leland or Liz?
I'm fine with holding until we get more guidance from up top.
Same here.
Also fine.
Okay, that's what we'll do for right now. We'll just hold on to the reconsideration request. If it becomes time to hear it, we will obviously let the parties know when that will be based on what we hear from the circuit court. Okay, moving on to extension requests. These are in tab 4. All right, so 2021-27, 1816 West Lexington Street. This one was supposed to be heard a month ago, and I printed out the wrong extension request, so we're hearing it now. This person, let's see. She is talking about replacing the water heater. It required an additional permit and inspection. I think she was adding a dwelling unit, which may explain why she needed to replace the water heater. The plumber has been unable to complete the final steps of the process. Let's see. Okay, there's just a lot of details here about the plumber and what he needs to do. They're asking for
60 days.
60 days, yeah.
And we're still giving, our levels are still at 6 months and 12 months.
Yeah, I think in this case, especially because we've had 2 extension requests from this applicant this year, we could just give a longer period just to allow her to finish things up if the board wants to grant an extension.
They're working towards it. Things keep coming up. I know the first issue was a health-related issue. And certainly we accommodated that. If the shortest amount of time we can give is 6 months, I would give 6 months.
The board can grant whatever extension you want. It's
Well,
just a matter of hearing it again,
Yeah, and
if
that's
she needs a little more time.
Unfortunately, I don't know if this is a snake-bitten appeal or grant of an appeal, but again, there have just been issues, and I would hate to have them keep coming back, every 30, 60 days for something that may be out of their control. So I'd be inclined just to grant the 6 months, but make it the last one.
Okay.
Oh, I agree.
I'm fine with 6 months.
I'm fine with 6 months.
All right, moving on to 2022-407, 5814 Hillen Road. You have that one second. This was related to an exterior perimeter wall for a BG&E facility, substation facility. There's some details here about what's been going on since the approval. complexity of coordination and engineering involved. They're asking for, what was it, 12 months, I believe? Yes, 12
Is
months.
the applicant's here.
Yes.
I just have a question. The letter states that BG expects to begin mobilizing equipment and materials to the property by December 6th. Has that occurred yet?
I do believe that they've started that process, correct?
Can you introduce yourself for the record?
Jennifer Bussey with the law firm of Rosenberg Martin here on behalf of the applicant.
Okay, welcome.
Thank you. And just to clarify one point,
Sure.
the wall is not the only issue, it was also the approval for the use in general.
Okay. So 6 months is probably not going to do it safely for you all?
So the complexity and the reason that the client has advised that 6 months is probably not going to do is because there are so many other properties involved in the overall network upgrade. And it's a domino effect essentially of what they need to do to move the materials to start the construction. So
Okay.
that's why they are asking for 12 months.
All right, I don't have an objection to 12 months.
I don't have an objection either.
I agree with.
No objection.
I apologize.
Okay, sorry about that.
Thank you very
Repeat
much.
everything you just said.
No.
and you would have to say.
It's okay, we can keep going.
Very well, thank you,
I
Mr.
appreciate it, thank you.
All right, 2022-403, 701 Druid Park Lake Drive. The applicant is here for this one as well, if you have questions. You might remember this hearing, request for a lot area variance to accommodate more units than the code allows. There was a lot of conversion and restoration that was planned to happen, which has required a lot of work, filing an application to CHAP. Let's see. So basically, they're going back and forth with CHAP approval for tax credits. Architect has a full set of plans prepared. Submission is currently delayed because a license holder is on vacation and unable to accept an invitation to join the permit. It should be filed by the time that we hold a hearing right now. But let's see, the original resolution date is December 20th.
And hi, I'm Chase Hoffberger. I can offer a little bit of clarification or update on that because while the vacation was certainly a hindrance, it is not the case that the permit application has been filed for. There's something going on right now with the permit application process that requires that subcontractors be added to the permit now if there's mechanical, electrical, and plumbing work to be done. And so in a project like this, it creates a level of confusion where you're asking somebody to sign on to plans that haven't been approved, timelines haven't been understood, so there's a negotiation process that needs to occur kind of with the subcontractors to make sure they're on board and can do it. So the property owner and the architect who have been working on this have been engaged in negotiations with the individual who will handle the electrical and the plumbing work, but that's not settled yet. So again, as Ms. Witt said, the application is sitting in the queue with just waiting on one person to say yes. If they say no, then they have to go find a new electrician, a new plumber to handle this. But we really hope to get this submitted soon. We just need a little bit more time, obviously, because we're running out of time.
So the process, wow, process allows a shakedown by the subcontractors to come to an agreement. before
Chairman,
we
those
move
are your words.
They absolutely are.
There has been a conversation about how much money should be
Right.
handed over prior,
Sure.
and
Sure.
what the architect and property owner are saying is,
Right, how badly do you need it?
how badly do you need it, and what's the scope of this? Just to clarify too, this hearing was originally held, the property owner owns the property next door on Druid Park Lake Drive, and the application for variances were heard together at the same time. That other property, which is 709 Druid Park Lake, has already secured its permits, construction's already begun, so it's not like anyone's walking off the property or the project here. They just need more time on this particular component.
All right. How much time do you need, do you think?
Well, if we've requested 1 year, I don't know how long the review process can take. I would hate to have it be 6 months and then come back if it's all the same.
But all you're trying to do is comply with the process that the city has in place by
Exactly.
getting these folks signed on. And
But the review process for the plans can take a bit of time.
Sure.
That's out of our control, as is usually the case.
So my understanding is the permits have been filed, but you're waiting on the subcontract.
Permits have not been filed.
Okay.
Permits are one small step from one man away from being filed.
Okay.
yeah, that's unfortunate. I'm inclined to give them a year because it is what it is.
Yeah, the permit
Yeah, I think
process can
years-
take 4 to 6 months.
Yeah.
Once they have it under review. So,
Exactly.
I'm fine with it. Well, a year.
A year.
Good luck.
Thank you.
I'm a yes.
All right, moving on to the final,
Wheels of justice turn slowly.
final extension request. So this is a little bit different. This was actually a conditional use that was granted by the city council. We've done this before. If the city council grants a conditional use, which they have the power to do, there's no way for them to, there's no extension option to the city council. So the extensions have to come to us, even though the city council granted it. I'm just the messenger here. So 43 South Carey Street, this is a request to the city council, which was granted through the conditional use ordinance process to convert a single-family dwelling to a multifamily dwelling. This particular single-family dwelling is a decommissioned fire station. I don't really understand how it was converted into a single-family dwelling. It must have been a very large one. But anyway, it was then granted under the current ownership to convert the existing single-family dwelling in this decommissioned fire station into a multifamily dwelling. Because of all the historical aspects of the project, they're having to work with CHAP, and because they're in a, obviously because they're in a historic district. So they need additional time to move forward. This is all the information that I have. The building permit was approved, but they haven't obtained their UNO, which is what they need for the conditional use. So they're asking for an additional year.
And there's no one here?
No.
So the building permit was approved in September 2023.
Yes. And they, looks like they've begun renovations. They just have not gotten their use and occupancy permit.
And it's the first request, obviously, so I'm okay. I don't have objection.
And just so I'm clear, the use and occupancy permit, the conditional use still has to be in place in order to be granted the UNO, and that's really the issue right now. Because if the conditional use expires, then they will not be approved for the use and occupancy.
Yes,
And so
that's
they've,
correct.
the conditional use expires now. Okay.
Yeah.
So they're just really one step away from the process. Okay, I'm comfortable with a year.
I'm a yes.
I'm also a yes.
Great, we can move on to the zoning docket at long last. I don't think, let me pull up my little script here for the zoning appeals docket. I know for sure there is opposition, just for the board's knowledge, on 2023-199, 2023-205, and 2023-206. So 199, 205, and 206 are the appeal numbers that have opposition that I know of right now. And I'll just get started with my little intro. Good afternoon. Welcome to the 1 p.m. docket for the BMZA. My name is Becky Witt. I'm the Executive Director to the BMZA. From left to right here, we have Leland Shelton, Victor Clark, James Fields, and Liz Cornish, who is our newest member, just confirmed on December 4th, I think. And then to my left is Jim Allman, who's Assistant Counsel to the Board. Please go ahead and silence your cell phones if you can. If you need to have a conversation, please do so out in the lobby. When it's your turn to speak, please come either, you can sit at the table here or stand at the podium. Make sure your microphone is on. So if it's on, it will be green. If it's red, that means it's off. And you'll need to identify yourself, spell your name for the court reporter who's sitting opposite me, and be sworn in to testify. If you haven't already signed in on the sign-in sheet and you plan to speak today, please sign in now. The board will probably vote at the end of your case, but the vote doesn't make the decision final. We have to issue our decision in writing in a document called the resolution, which is a process that takes several weeks. The board will need to review them and adopt them at their next meeting, which is not until January 16th, I believe. So the resolutions will not be issued before January 16th. We will send them to you via email when they are ready. If you're unhappy with the outcome of your case, you have the right to request reconsideration of the board's decision within 10 business days. You also have the right to appeal the board's decision to the circuit court within 30 calendar days of the issuance of the resolution. And that's it from me.
Okay. Thank you all for your patience. Again, apologies for the delay getting started, but one could say we're right on time. Okay. Just a couple of cautions. We do intend to, and typically would, resolve your matter by deliberation today when you present it, unless we find that there's some additional information that we think we need in the record, or just some additional facts, factual development, and we'll ask you to come back. But that choice is really going to be yours. The way we do that typically is to offer a postponement so that we can hear more. But if we've heard it and we still need more information, then it probably behooves you to get that information and come back so that we can fully consider your application. To the extent we have opposition on matters, I know we have a few of them today, and to the extent there are multiple folks who wish to be heard on that opposition, I'll ask you to pay close attention to what some of your peers have stated before you in support of that opposition, so that you're not sort of repeating things we've already heard. If there's an issue such as parking, the point is we don't necessarily want or need to have 10 people come up and say, we're concerned about parking, because we get it. So with that caveat, and certainly don't proceed with regard to your project until you have received a written decision, and certainly don't begin to perform work in Baltimore City without getting the proper permits. And so with that, we'll go ahead and begin calling the docket. I'll just go from the top and go from there. So the first case is 2023-148, 1543 Appleton. Malik Royster is the appellant. Are you Mr. Royster?
Yes, I'm Malik Royster.
Good afternoon, sir. Press the button and there you go.
Yes, I'm Malik Royster.
Okay, and this is a request to use the premises as personal services establishment, a barber shop, a retail goods establishment, and 2 dwelling units requiring conditional use approval and confirmation of non-conforming density. Is that correct?
Yes.
All right. Can we get Mr. Royster sworn, please?
Please raise your right hand, sir. Do you swear or affirm under the penalty of perjury that the answers that you give in the statement say you make the truth, the whole truth, and nothing but the truth?
Yes.
I do.
All right. I'll hear from staff and planning.
Okay, so conditional use, there's 2 conditional uses that are needed here. One for personal services establishment, one for retail goods. No alcoholic beverages sales are allowed for the retail goods. Also, no tobacco sales are allowed, just FYI, under the neighborhood commercial section of the code. And then the second, I guess, category is for non-conforming density. So there, according to the land use cards, there have been 2 dwelling units on the first and second floors of this building already. So he's asking to continue to use those 2 dwelling units. And there's a history of this property being used for a barber shop, clothing store, over the past I would say 60
70
years.
years.
So there is a basis for neighborhood commercial establishment in the zoning cards.
Martin French for the Baltimore City Planning Department. Planning Department has reviewed this application. You've heard the details from your staff. Planning Department agrees, same details, and the department has no objection to approval of the application. Thank you.
Thank you, Mr. French. So, Mr. Royster, the barbershop, I certainly understand, the retail goods establishment, what is it you're seeking to sell there?
I really haven't gotten to that point in time where I decided what I'm gonna sell yet, to be perfectly honest with you. Probably clothing store, most likely.
Okay. And you're not required to have that level of detail, but, because you otherwise appear to qualify for that, as long as we certainly abide by the code requirements, which is, as mentioned, alcohol sales are prohibited,
Right.
so it wouldn't be that. You know. And you're
Right, no
in agreement with
alcohol.
that, all right? And so the two apartments that have existed at this location, you know, you have personal knowledge that they've existed for a
Yes.
period of time,
Yes.
okay? Are you aware of any information that would suggest that a barber shop or a barber shop and a retail goods establishment in this location would somehow be a detriment to the community?
No, like you said, it's been that kind of establishment for 70 years. Pillar of the community.
All right. What are the hours that you intend to operate the barber shop?
Daylight hours, 9 to 5.
Okay. That's 6 days, 7 days a week?
Yeah, 6 days a week.
All right. Any questions for Mr. Royster?
No.
All right.
No questions.
All right, sir, thank you. Appreciate your application. As to the conditional use request, doesn't appear to be any evidence in the record that the operation of a barber shop in this location or a retail goods establishment would be detrimental in any way to or endanger the public health, safety, or welfare. It's certainly not precluded by any other law. This authorization, I think, would be consistent with the public interest and not be contrary to the public interest, and would also be in harmony with the purpose and intent of the code. The operation, at least the barber shop, will operate 9 to 5 days a week. And it doesn't appear that the operation of the barbershop or retail goods establishment would engender any other issues, problems, impacts beyond that which would exist for any other location in this zoning district. So I'm a yes as to the conditional use. And with regard to I think we have confirmed based on the record, the non-conforming density of 2 dwelling units haven't existed in this location for a long period of time, certainly back to 1957. And so I'm a yes as to the application for those reasons.
I'm a yes.
I'm also a yes.
Also a yes.
Okay, thank you, sir.
Thank you.
All right. One matter we may take out of turn, because we have a council person here. We tend to give them, I know you got to get back to the work of the city council. And so that matter is, which one?
199.
199. It's a matter of which we have opposition, but again, just, and for purposes of everybody who's here, oftentimes we'll have, or sometimes we'll have council people and other city officials come to be heard in connection with the matter. And again, given the level of importance that their work requires, and that we want to wish you Godspeed to get back to that work. We want to take you out of turn in this docket. So I'll call case number 2023-199, 1911 East 31st Street. Anthony Diggs Sr. is the applicant. I understand there's a fair amount of opposition here, so could everybody identify themselves or stand up if you're here in support or opposition for this particular matter?
Counsel Robert Littman on behalf of Anthony Diggs.
All right, welcome, Mr. Littman.
And just for the record, it is Anthony Diggs, not Riggs.
Gotcha, sorry.
Thank you.
Anthony, it's Anthony Riggs, not Diggs?
It's Diggs, not Riggs.
It's Diggs, not Riggs.
Yes.
Okay, oh, I said Diggs.
Following motion in opposition.
Okay, because the reason I want to identify you all, because we got to get you all sworn.
Okay.
So
Shall I?
let's go ahead and do that. And first, let me just fully call the case. 1911 East 31st Street. Anthony Diggs Sr. is the applicant, or is the appellant. And this is a request to use the premises as a multifamily dwelling with 3 dwelling units requiring confirmation of non-conforming density. Is that correct, Mr. Lippman?
That is correct.
Okay. Could we get the parties and witnesses sworn, please?
Raise your right hands. Do you swear or affirm under the penalty of perjury that the answers that you give in the statements that you make will be the truth, the whole truth, and nothing but the truth? Yes. Thank you. Mr. Lippman, can you spell your name again? Or just spell your name?
Robert Littman, L-I-P, as in Peter, M-A-N.
Thank you. And then, Mr. Chair, if whenever a witness comes up, for anyone who's going to come up and speak, I'll ask you to state and spell your full name for the record. Thank you.
Very well, that'll be fine. And when you do come up, the opposition will hear on this side at the table. Feel free to bring some other chairs up, but we don't have too many folks there. We'll hear from staff and planning.
All right, the request is to use the premises as 3 dwelling units.
Ms. Witt, can you speak up?
Can I speak up?
I'm having a hard time hearing you.
Sure. All right. The request is to use the premises as 3 dwelling units, multifamily dwelling requiring confirmation of non-conforming density. The last authorized use of the premises in our records is for a multifamily dwelling consisting of 3 dwelling units. And just for the board's information, 3 apartments were approved in 1931, which continued through updated permits through 1967. So that's the last date that we have in our file. When a use and occupancy permit was issued is 1967, but we don't have any intervening permits after that for any other kind of use.
Okay, thank you.
Planning Department reviewed this application, noted that this property is located in the Coldstream Homestead Montebello Urban Renewal Plan area. That particular urban renewal plan does not prohibit or specifically restrict the proposed use in the district. The plan does have a prohibition against residential conversions, but if there is evidence that this property was converted prior to the enactment of the urban renewal plan, then obviously it's now a non-conforming use under the urban renewal plan. The department also notes that the urban renewal plan has specific goals in it for increasing opportunities for home ownership, encouraging rehabilitation of vacant homes, as well as new construction, and rehabilitation and preservation of existing housing stock in areas of strength. The department therefore has no objection to this application. Should the board determine that the application is approvable, the department recommends that approval of the application be subject to the condition the use of the property complies with terms and conditions of the Baltimore City Code, Article 23, which is the sanitation code. Thank you.
Thank you, Mr. French. Mr. Lippman, is your client agreeable to that condition?
Yes.
Subject to Article 23?
Yes, sir.
All right. We'll hear from you.
Sure, just briefly, but for the granting of this continuation of this variance, there would be a 1 unit that's already been finished that has long been, well, at least formerly was for a long period of time, used as a 3rd apartment. So again, but for the granting of the variance, that it would be sitting there. And what would that mean for the health, safety, and welfare of the community? It would mean that my client, who is a property investor in Baltimore City, young guy, would be inclined to want to increase prices for his other properties. There would be a property sitting vacant. And, I think when you weigh that, the existing circumstances against the understandable but relatively, dare I say, minimal impact on issues such as parking and foot traffic. I would suggest that clearly the continuation of this variance is appropriate under the circumstances.
Okay. All right, thank you, Mr. Lim. Any questions for Mr. Lippman?
No.
Okay. Ms. Witt, for the benefit of the record, and we just had an issue, a case for addressing non-conforming density, could you give us more than a 50-cent, sort of explanation of what that issue is and how it's been handled within the city and by the zoning board?
Sure. So before transform, let's take it back a while. Anytime a property became vacant in the city, the board had to consider it to be a single-family dwelling. And then the board could decide whether or not to grant a residential conversion from a single-family dwelling into a multifamily dwelling. So in this, as in a case like this, let's say this property, 3 dwelling units, it doesn't comply with the minimum lot area, meaning that there are too many units on the property given its square footage. If it became vacant under the previous version of the code, the board would have to consider it to be a single-family dwelling and then think about whether it should be converted into a multifamily dwelling, even though in reality it's sitting there, it's already a multifamily dwelling. When the code was changed, that section that says the board has to consider all vacant properties to be single-family dwellings, that was removed. From our understanding, on purpose, it was removed because it, under the council at the time, believed that that was getting in the way of vacant properties being redeveloped if they have to go through this process, this conversion process, to be able to be used the way they've always been used. So now that section doesn't exist, and there's this thing called nonconforming density in section 18206. It says that if whether a nonconforming density or other form of nonconformity exists is a question of fact that has to be decided by BMZA. So that's why the case is here. The way that the board has interpreted it since I've been here for the past 2 years, probably more than that, is that the board will approve whatever the last legal use of the property is, even if it's nonconforming. This nonconforming density thing, because basically the structure is nonconforming under the bulk regulations. So let's say, this is getting to be long, but let's say a structure in a certain zoning district is supposed to be 10 feet back, but it was built 5 feet back under a permit legally. At some point, the code changed and said, now you have to be built 10 feet back. We don't require people to tear down part of their building or to alter their structure in order to conform when the code changes. So this is kind of the same thing. It's non-conforming with respect to the density, meaning it's basically a non-conforming structure. And as long as that structure continues, that's the board has interpreted that to be okay. So that's basically the situation. The board has to find that there's non-conforming density here, that there's an existing non-conformity with respect to the structure. And so the board has to find that there's testimony that there are 3 units here and match that up to the last legal use of the property, which is 3 dwelling units. And so the board has been approving those as long as the existing number of units matches the last legal use. The board has been approving that as existing non-conforming density. I hope that is helpful.
Thank you so much.
Yeah.
It's certainly helpful to the record, yep. Very well. Okay, Councilman Ramos, or anyone else in opposition, you can choose whatever order you'd like. Come on up.
Do you want us to be here?
There at the table, please.
And
I haven't been here in a while.
turn the microphone on,
Yeah,
press the
press
button. Thank you.
And Mayor, if you could stay at the podium.
Sure. Good afternoon. I'm Councilwoman Odette Ramos, Odetteramos, from Baltimore City's 14th District. proudly representing the Coldstream Homestead Montebello community. I'm here in opposition and supporting the community's request for opposition. During Transform, my predecessor rezoned this entire area as R6 in order to avoid the very situation that we are in now. This is a neighborhood that is proud of its history, but also that has had a lot of challenges. And one of the things that they are working hard on is to revitalize the neighborhood. There's a lot of investment happening, which is great. But their preference, as was stated in the urban renewal plan, is for single-family homeownership. And so the 3-unit issue is something that is not something that they want to have happen. When I look at the rest of the block, most of it is single family, and so it is consistent with the rest of the block. I do have some question about the categorization as for nonconforming density, because the definition of nonconforming density is actually not in the zoning code. There is nonconforming use, nonconforming structure. Nonconforming density is only listed in the paragraph that Ms. Witt had talked about. So there isn't a lot of guidance as to what this would actually be, other than what the practice has been through what the zoning board has already done. So I'm asking your consideration to be consistent with the neighborhood's plans. We are seeing success in addressing vacant properties in that area by rehabbing for, single family. And that has been consistent in the most recent rehabs in the area. So we're asking for the same here. So it's not out of the question that we'd be able to address vacant properties in that area without having to convert them. Thank you for your time.
All right, any questions for the councilwoman? Thank you, Councilwoman.
Thank you so much.
All right. Anyone else?
Yeah, there's 2 more.
My name is Faule Umoja. FAOULYUMOJA. I understand what y'all was talking about the non-conforming density and all. And I understand that it is seemingly directed in our community, but it's not directed in Roland Park. It's not directed in Guilford.
What
It's
makes
not-
you think that?
Because those individual areas have covenants that is not broken, and ours is not. And it seems as if where our areas have single-family dwellings, and you go back to 67, as he said he wanted to go back to ours, and when that house was considered, when they moved out and became a single-family dwelling, and they want to leave it as that, and then somebody want to come in and forget the human factor, and as he said, profit. He wanted to make money, not considering the human factor. It's all about money that these individuals want to have more people in this area. I know you say don't bring up parking, but it's a
I don't
very
say don't bring up
interesting
parking.
thing. I heard you say something about it.
He just meant don't duplicate
Okay,
concerns.
since I'm the one saying it and
if
it's
somebody,
not.
you're it. If anybody else has
Tag, you're it.
parking
But
concerns,
when you want to
then
bring in multiple people, you have 30 houses on the block, 2 people in each house, 2 cars, 60 cars on that block on one side, 60 on that side. It's too many houses, too many cars, multiple dwellings, multiple people in the houses. Have it his way, we have international 500 on one block. We cannot have that. So with people wanting to have multiple dwellings, we will have a low-rise project in our neighborhood with these people bringing in so many multiple dwellings. We cannot have that. He wants to have one, and everybody he knows will try to buy a house around there, want to have more, because the only thing they're thinking about is making money. This is a capitalist who wants to come into our neighborhood. I'm not calling names, but this is a capitalistic type situation where people only want to make money. I've been living in my house right in back. I live 1932 East 30th Street. He's talking about 1911 East 31st Street. It's, our alleys are the same.
Well, you would agree, would you not? And this is not to challenge the societal and social concerns in the neighborhood, arguably improvements that you want to seek, but the house was built as a 3-dwelling unit property, was it not?
The house was built over 50 years ago.
And the legal use, at least based on our records, is that it was utilized as 3-dwelling units.
Over 50 years ago.
Yes, sir.
And the times has changed, situation has changed, the housing complexity of the neighborhood has changed. Everything has changed. And considering the complexion of today, when he's doing what he is talking about today, we're in a different era. And it's going to be different as of today. So I'm asking you not to do what he want today.
Would it be fair for the board not to apply the standard that it has established as advised by, the law department, legal advice that this board gets, for this instance, when across the city, when the same situation presents itself, this is the application of the standard. Hold on, only one of us speak at a time. This is the standard and the application of the law based on the history of zoning that has been applied. Would that be fair or unfair to the individual who presents, as many other folks have, whose property does not conform? I understand it's your neighborhood, but tomorrow it'll be somebody else's neighborhood with another individual presenting just as this applicant. And again, the standard that's been applied to all such applicants in that category have been uniform.
I understand what you're saying, and since you're on the zoning board.
Yes, sir.
And I understand his position.
Sure.
Young man, I definitely understand your position.
Sure.
Now take this into consideration.
Yes.
Since you're sitting on the zoning board, look at the neighborhoods that this is happening in. That's all I want you to do. Just like I said, Guilford. Just like I said, Roland Park. Just like I said, other areas. Simply look at the areas that they live, these things are happening, and then consider the human factor. Thank you.
Thank you, sir.
Mr. Chair, I just wanted to correct one little thing, because I don't think the record shows that it was built as a multifamily dwelling.
Okay.
But that it was probably built as a single-family dwelling, but that it was converted in 1931 to 3 dwelling units and has been.
1933.
Okay.
Okay, and so we have a legal use as
We
a
have a legal
multifamily dwelling.
use as 3 since
Stand
the
corrected in terms
30s.
of as-built, but certainly in the historical use of it as a multifamily dwelling, and that's the last record we have of its use, correct? Okay. Mr. Washington, welcome.
Welcome, thank you all. Happy holidays.
Same to you,
Mark
sir.
Washington, M-A-R-K, W-A-S-H-I-N-G-T-O-N. Thank you all for your time today.
Sure.
I'm glad the record was corrected because we are picking an arbitrary point in time to make this decision. And that arbitrary point in time benefits the use of the investor. I would like to have read into the record the opposition letter that we sent to the BMCA. Would someone mind reading that into the record?
It's in the record.
I would like for it to be stated publicly here. Would you all mind reading that into the record?
Well, would you like to read it?
No, you can read it.
Well, depending on its length, it's in the record, so it's a matter of evidence for consideration by the board.
I mean,
It can be read in less than 2 minutes.
Go ahead and read it, Mr. Washington. Go ahead, sir.
Well,
That's part of
that's
your
all right.
testimony.
Leave it there. I've got something else that I'm going to present. The reason why I wanted that read into the record is because I think that opposition letter to BMCA
Go ahead.
deserves a public airing. Since you all already have it in the record, you know what was stated in that opposition letter. And you all know that the opposition letter reflects the fact that this structure was not originally constructed as a multifamily dwelling unit. You also understand, as was written in that letter, that this choice that you all are making is to pick an arbitrary point in time and to use that as the basis for approval.
Sir, can I pause for 1 second and ask you a question? Why do you say it's an arbitrary point in time?
Because you all are going back to the 60s. You read the letter, correct?
Yes, I've read it.
Okay, so then you know that was one of the most bleakest moments in the history of the community. And when we mention what is codified in law, it was codified in law at that time that discriminatory practices be applied against African Americans. It was also codified into law that the robbing of the wealth of individuals who had these single-family homes was allowed. Also in the letter that I pointed out that at the time that this conversion was allowed during blockbusting, the population of Baltimore was near 1 million. I think we're at 550,000 right now.
585,000.
505,000, even 585,000. Thank you for the correction. But nowhere near 1 million. And so what was also pointed out in the letter that I sent was the simple laws of supply and demand. And so if we want to use as a basis for our decision a horrific point in time that was codified into law, and this is something that bears to be said, that was codified into law, the discrimination against African Americans, then I think we are using the law to perpetuate something that was undone years ago. I stand before you all today to express my deep concern regarding changes that seem to disregard the community zoning and URP protections established to guard against the conversion of single-family homes to multifamily units. These protections were implemented to maintain the character and cohesiveness of our neighborhood, reflecting the collective will of our residents. Altering these safeguards has compromised the integrity of our community, eroding the shared vision that has guided our zoning policies for years. It is crucial to emphasize that the protection against such conversions was not arbitrary. It was carefully crafted response to the needs and values of our community. Ignoring these provisions in favor of changes that prioritize individual interests risk undermining the stability and identity we have worked so hard to maintain. Furthermore, the zoning changes, and you all need to understand this, furthermore, these zoning changes can have a direct impact on property values. By increasing the supply of multifamily units, the delicate balance between supply and demand is disrupted, potentially leading to a depreciation of property values. As we tamper with the established protections, we risk introducing imbalances that may not only affect the economic well-being of current homeowners, but also alter the very fabric of our community. It is imperative that we proceed with thoughtful consideration, weighing the potential consequences of these changes on both the character of our neighborhoods and the financial investments of our residents. And what you all are saying is that in a community that has an abundant supply of the housing with limited demand, in a city, by your own admission, that has only 585,000 people, a decrease from the near million back in 1961 when blockbusting was the law that you all want to use to advance this request. You all are saying that the wealth accumulation, which was denied African Americans for so long, which was also codified in law, should persist and continue. And that, I think, is unfair of the integrity of this board. Thank you.
Anyone else?
I want to raise, is there any more
No,
opposition?
go ahead. Any other opposition?
I think you all have those letters from residents that were submitted.
Yes, sir.
We have
Yeah.
them, yes.
Everything's submitted in the record, we have and taken into consideration. Thank you. Anyone else in this case? All right. Go ahead, Leland.
Since the 2000 census, Baltimore has lost nearly 66,000 residents. We're sitting here today talking about putting units back into the housing supply in a neighborhood that has seen significant population loss and disinvestment. So I would also say that perhaps adding more density and adding more units could also be a good thing in a city and neighborhoods that are losing population. And you also talk about changing the character of the neighborhood. You're inferring that renters somehow will bring down the property values of your neighborhood and change the character of your neighborhood. I want to reject that notion that only property owners are people who should be respected and should be able to live in our neighborhoods and our Black neighborhoods. I grew up in the Green Mountain 33rd community. I went to Baltimore City College, which sits right there at Coldstream, Homestead, Montebello. I remember what those neighborhoods looked like before we saw a significant blight reduction that we see going on today. So I just really want to make sure that our neighborhoods deserve investment too. Black, white, Roland Park, they don't want more units. Other communities don't want more units in multifamily dwellings. But somehow, we want to reverse the loss of population that this city is seeing. At some point, and you talk about the degradation of character in neighborhoods. Blockbusters use those same theories. Redline use those same theories. Renters are moving in. They were all dog whistles about Black people moving into neighborhoods and changing the character of our neighborhoods. And now you're using that same language in the name, that same language in the name of protecting Black communities. It doesn't all line up.
Mr. Shelton,
Yes,
if I
sir.
may respond, your premise is flawed and incorrect. I never used the word renters. And as far as investment,
I picked up what you were putting down. That was the
I'm sorry,
implication because
I'm
these will be
I'm
rental
about to
units.
make clear, even clearer, what I was putting down. Your premise is flawed and it ignores math. Right now, the city of Baltimore, by your own admission, has only 585,000 residents in it. What we are saying is that our community has too much supply and not enough demand. The laws of math are simple and finite, which means the greater the supply, the lesser the demand, the lower the property value. If you want to espouse to me what is in the best interest of African Americans, I would caution you to recognize the fact that those African Americans who are homeowners decide and should have within their ability the ability to generate wealth as was afforded to other non-minorities through government action. Also, as far as investment in the community goes, it shows a lack of research on your part because Coldstream Homestead Montebello is engaged in the full conversion of taking unoccupied vacant
Very familiar.
properties and converting them into affordable housing.
Unwell.
Secondly, we are in the throes of doing a new development project that will bring additional housing units into our neighborhood. But make no mistake about it. To take homes that are consistent in character and architecture with those that have been preserved in Oakenshaw, and to say that we want to allow, based on a law from 1961, the addition of 3 units in our neighborhood only increases supplies and undermines the value and wealth that we are trying to create for African Americans in our neighborhood. Do not, and I repeat, do not use that argument as a way to try to inflect or suggest that Coldstream Homestead Montebello is not about protecting the interests of African American people and its residents.
I know you are. I just think that you think I got the premise wrong. I think you guys also have the premise wrong. And we can respectfully disagree.
I don't
We can
think there-
respectfully disagree, sir.
I don't know that we disagree. I think we're looking at it from 2 different vantage points. Your vantage point is you believe that introducing more housing stock into an area where demand is limited will somehow magically increase property values. It will not. How do we know? Because we've proved it by taking the development actions that we've been engaged in for the last 2 decades. So unless you can provide to me real scientific proof that introducing additional housing stock into an environment where demand is already low will improve property values, I would suggest you not raise that argument again.
Thank you. Thank you. I also want to say this: for nearly 100 years, this probably has been a 3 3-unit multifamily dwelling, sir, for nearly 100 years.
Okay,
Improving
all-
it and keeping that way is somehow
okay, I'm
bad for
sorry.
the neighborhood.
I've got questions.
Yeah.
I'm sorry. Let me respond to
Sure.
that very quickly. If you read what was submitted, it said the original intent of the structure. The original intent of the unit was single-family row home. The fact that it was allowed to be changed by some political process is something that individuals outside of those who originally constructed the property decided was in the best interest of the city. Just as those who decided that blockbusting would be in the best interest of investors and profiteers. So when we go back, and that's the reason why I said arbitrary date and time, because if you want to use a date and time to support the community's position, you could just simply go back to the original construction date and say, oh, this thing was originally constructed and intended to be a single-family home. It is through a political process that we allowed that to be undermined and changed. You had a question, Ms. Cornish.
Yeah, and this might be for the planning department or legal, but obviously if you have input into that, these are just kind of more technical questions. So the house was converted into 3 units, as far as we know, in 1933. Okay. And then how, prior to your client, sir, purchasing the property, how long was it vacant? And Councilman Ramos, so yeah.
The most recent vacant building notice is 2018. But I would argue that it's been vacant longer than that.
Because you work so closely in housing, I'm very interested in your sort of expert opinion about why you think the property has remained vacant for so long.
Well, we do have significant vacant properties in the area. And yet, as I stated earlier, there's a lot of activity now. And there's a lot of opportunity now. People know that there's a new development coming in, so I think there's some excitement about that. There's obviously, we're making a lot of our processes a lot easier and better for people to acquire properties, to be able to do rehabs. And the community has worked very hard to have redevelopment partners with them as we work on the rest of the community. I can't speak to that block and that particular house specifically, but I do know that 1909 and 1907, is it 1909? 1907 just got rehabbed into single family.
And that was multifamily to single family, or just it was rehabbed?
It was rehabbed.
Okay.
Yep. Yep. And so there are some houses that have been might maybe been 2 units back to rehabbed, but also since this was rezoned R6 during Transform, there may have been, as in this case, where there were some multifamily that were made at the time and earlier. So it's an exciting time for Coldstream Homestead Montebello in order to see that there's been some headway on addressing vacants. And I understand the concern. I mean, I want every house to be rehabbed and make sure that we have people in them, not just in my district, but citywide. But the priority of this particular community has been to make sure that there's single family. And it may be renters, it may be homeowners, but to have single family. So, and we do have across the street many homeowners that have been longtime homeowners there.
So, and just trying to take that logic a little further, the community would prefer that a building currently constructed is 3 units, that the next person that owns that property or the current property owner rehabs that property as a single family home. What are some of the challenges, do you think, of why it's remained vacant since 2018 in terms of,
Can I answer that?
I'm just curious about kind of what's going on in the neighborhood in terms of the challenge of selling it as a single family.
First, when we go back to the 60s, understand that the Chum Urban Renewal Plan also goes back to the 60s. And what you all are suggesting today flies directly in the face of the Chum Urban Renewal Plan, which mandates a decrease in density. The reason why our forefathers and foremothers determined that was needed action was because they saw and felt and lived the effects of blockbusting, taking these single-family row homes and putting 2, 3, sometimes as many as 4 units in them. I had asked a council person well over a month ago to bring BMCA out to take a look at this property in person and then take a ride with me right up 33rd Street, not even a mile away to Oakenshaw, and see the exact same architectural units that have been preserved as single-family homes. The reason, to answer your question, that the property itself has remained vacant since 2018, quite frankly, has to do with the community, and the community pushing back on uses that are unacceptable and fly in opposition to its URP. The other reason is this, is that the community brought in healthy neighborhoods almost over a decade ago. That investment into that particular blocks and the blocks that surround there have led to improvements such as lighting upgrades to improve public safety, low interest loans for residents to improve their homes. A year and a half ago, we had a resident who had a multifamily dwelling unit who sent a letter in opposition, converted into a single family home. While work is still going on at this young lady's house, I asked her to have it appraised. She was shocked when the appraisal came back in excess of $300,000. Now, what we're doing to residents in this community, let's be clear. You all have to make a decision of conscience, okay? Whether or not undermining the opportunity that these individuals had been robbed of for so long, because prior to my arriving there, property values in Chum were sinking to an all-time low. And we made the tough decision that 8 acres, a blighted area in the community, had to be acquired so that we could create a new footprint that would allow residents who had been there, some longer than Mr. Amosia, to see that their homes and property had value. But in addition to that, going back to rentals and public housing, for those of you, and I'm sure you don't know, I lived at 725 East Myrtle Avenue. You know where I'm talking about, okay? My family moved to that community first as a renter and then fought to become a homeowner. So we welcome renters in our community, but that's not what we're talking about here. We're talking about the recreation of predatory practices that see a community on the upswing and on the rise, and investors now swooping in. We cannot, we must not support that action. We cannot take this step backwards, because if we do, then all the work that these residents have worked so hard over the last few decades to achieve will be completely and totally undermined.
And just to add one other thing, the property has changed hands several times.
Yeah, I'm just looking.
You've seen that in SDAT. And I do think that there's just been a lot of people just having interest and then not being able to do anything with it or not wanting to do anything with it. And I do think
that's because they couldn't use it for the apartment dwelling.
Right, and so, but I do think that there's, as we know in Baltimore City, there's been a lot of people who sit on properties and just kind of wait for the, to value to rise, and then they'll do something with it. And I think that's what's happened in lots of neighborhoods, including this one, where we've had a lot of people sit on them for a long time, and now we're seeing activity. But we do have a lot of positive momentum given the development partners that we have in the neighborhood as well. So as we've been seeing positive things happen, then people are like, oh, well, let's finally do something with the property. So I think that's a little bit of what happened there.
And I would be remiss in regards to this property if I did not mention the stalwart effort of our previous council person, Mary Pat Clark. You want to know the real reason why it stayed vacant and the real reason why it changed hands? Because Mary Pat confronted these individuals and said, no, you will not be putting 3 units in this building. And so when that revenue stream was lost to them, because no one ever says, oh, we're here to just profit and move on. They all have some great story of how this will improve the community for residents who don't know what's best for them. But Mary Pat stood up and said no. And we said to Mary Pat, and she understood this, that sometimes a building sitting unoccupied is less deleterious to a community than what is allowed or approved to go in it. And that's why you see the changing of the hands, because she stood up and she fought against it.
Let me ask a question.
I was going to chime in anyway, so go ahead.
It may be on the same issue, but the question that I have is the issues that are being raised, which frankly suggest that the law that we've been advised and how it's been applied somehow is violative of sort of pre-existing, illegal activity like blockbusting that put the property in the position of being allowed to be a 3-story or 3-dwelling unit property back in 1960. My understanding is the way that zoning has applied situations like this for all neighborhoods that may be trying to progress out of renters or multifamily into single-family homes. If you had it in Roland Park, if you had it in Guilford, if you have it in Oakenshaw, if the same situation presented, the law and the way that we are applying the zoning code would still be the same. There would still be someone suggesting that you're failing to look at the history of how it got to be this way or how it got to be that way in 1960, so we shouldn't do it now. In those situations, typically, it would take some legislation or some kind of city council ordinance or something other than a request that you look back at the history, because there's a lot that we could change if we just did that. We're looking at how the property was legally identified. It was a 3-dwelling unit. And we do that when we apply this non-conforming density, correct, to any property that has a legal identity. And a legal identity here is a 3-dwelling unit. So we can't change that. That is a fact. What would be required for an urban renewal plan, such as the one in Homestead Montebello, to sort of preempt the way that what we think or what we've been what we understand to be an applicable, an appropriate application of the zoning code to this situation.
That was a long question.
It was.
I will do my best to answer it. So I do think that this is very much a legislative issue. To the extent that it's a problem, it's a legislative problem. We've been having this exact conversation about this property, about another property that with a very similar fact pattern in this neighborhood specifically with this council person, about the way that the law was changed at a certain point. And the law can be changed again. It could be reverted back to the way it was before transform. It could be reverted back just in this zoning district of R6. It could be narrowed in that way. It could be added to the urban renewal plan so that that rule that used to apply that if something's become vacant, it's treated as a single-family dwelling, maybe that could be added to the urban renewal plan. But those are all steps that have not been taken. And so the board is charged with enforcing the code in good faith as it's written, the plain language of it, and consistently. So I guess that's how I think that answers your question.
It does.
And I've been looking into all of those options to try to figure out what's going to be the best.
Can you get a little closer to the microphone?
Excuse me, I'm sorry. We've been looking into
Do it, Cal.
the various those various options, obviously weighing impact citywide versus in this particular neighborhood, et cetera. So,
Sure.
Understanding that, we have been talking about it.
Good, and I appreciate that, and it's not necessarily pushback. I do reject the suggestion that the board has to make a vote of its conscience in connection with this issue, because we do have a code and we do have an application for the code, and it's uniform regardless of the neighborhood we're talking about, regardless of the area in the city. That makes it, one, certainly easy to apply, but two, it also provides a footprint as to how to move past that. And it would be, as it typically is with other issues, that we really can't do anything about, based on how we feel, is to take legislative action, through the city council. draft an ordinance. I'm not aware of, for a number of times that former councilperson Mary Pat Clark was here, what legislation was introduced to support what it is, or the direction that this organization in this neighborhood is seeking to go.
Yeah, she put in an R6 thinking that R6 would take care of it,
Yeah,
and that is not
and
what
apparently it's
happened.
not enough. And so, from the standpoint of at least, this board member, it is a process of the legislation that would, one, shine the spotlight on it even greater, and granted, it may be meandering around and figuring out how to get there, but it seems to me that's the work.
The case
has
that
to be
Ms.
done.
Witt brought up earlier also wasn't exactly the same. We were also looking at a different factor, like the inconsistency between the zoning code and the building code. The building code says multifamily is 3 units. The zoning code says the multifamily is 2 units, or did I get that reversed? And so
Right.
the inconsistency was the problem in that particular case,
Sure.
which I've attempted to address and have gotten extreme resistance from both users of the zoning code and the building code. So, it's not like we're not trying to solve the
Sure,
situation.
understood.
So,
And I think it's in the right
Mr.
direction.
Fields, if I may, because I was there when Mary Pat introduced the R6 designation for Chum. The R6 designation at the time that Mary Pat introduced it was the protection for Chum to prevent the action that is being requested here today. We believe now, as we did then, that planning through Transform decided to do an end around our council person and that R6 protection that we were afforded and said, no, here's what we're going to change and do in Transform. So much so that the current council person wrote a letter to BMCA saying, I cannot believe Mary Pat would agree to this. When she, Mary Pat Clark, in an effort to protect us from being here today, had the zoning changed. And as far as what the law is today based on bad policy of 1961, if we're using that as justification to continue to perpetuate bad policy, then something is wrong. Because as we all know, there have been laws that have specifically applied to our people in particular that were at once codified into law that had to be changed. That time in history was one of the most stark and bleak for our community. And to use that which allowed that to happen as the basis for allowing it to be reestablished today leads us back down a road that decimated the community and put us in the situation that we are in and trying to dig out from under now. But make no mistake about it, Mary Pat did put those protections in there.
And I appreciate that. And what that suggests to me is that there needs to be more protections and they need to be codified. And until they are, just like all the other time we had to wait until the law was changed to make it not more palatable, but fair and right, we're stuck with the legislation that we have. If it was the effort of whomever created Transform to do an end run around, then apparently they did their job. I'm not saying that's true or not, but to pay homage to what you suggested, we're dealing with Transform, and the board has to deal with what's in place. And the way that it has dealt with it across the board with regard to situations like this is to acknowledge the fact of the pre-existing or the history of the particular property as a multifamily dwelling, and to identify it and accept it as a non-conforming density. And so I hear you and appreciate everything you're saying, but it's not for the board to legislate, which is really what it's going to take to ensure those protections that Councilwoman Mary Pat Clark and Councilwoman Ramos are seeking, and you, on
Yes.
behalf of the community.
Mr. Fields, we weren't asking the board to legislate this. But understand, there was no public redress to transform. When we tried back then,
And I appreciate that. And
so.
what I'm saying is, there's not going to be a public redress of
No,
that
I
today.
understand that. So what I'm saying is what we're asking from the board is not to put forth a legislative remedy here. What we're saying to the board is to use good judgment. Okay, that's all we're saying here. It's the same thing that I said in the letter that I wrote, to examine all the facts and all the implications, and to understand that there are repercussions that will ripple out for years to come from the decision that you all make here today. How do we know that? Because we're still trying to dig out from under a similar decision that was made almost a half a century ago. You all have, I believe, the moral fortitude to do what's right.
If I may,
Yeah, you get the last word, because
Briefly.
actually you're the appellant. So
I-
I know it was a long time ago, but come on.
I hear, understand, and to the extent advisable, empathize with the idealism of surrounding property owners. As the board has as chairman has alluded to several times, we are charged with dealing with what is real. And what is real is that we have 3 units existing. 1 unit otherwise would be a otherwise vacant unit will be put to use by an owner of a property that has not been owned and has not had as a sustained owner, has been vacant for a period of years leading up to this point. So, I mean, do we play the cards that were dealt, or do we strike in the dark in an idealistic fashion? And, I am not the owner. I would also add, he is vacationing in Liberia, so.
Thank you, Mr. Rowe.
Thank you.
Appreciate it. I believe it's incumbent upon the board to apply the usually application that we've utilized previously in this factual scenario. Given transform, given how the code has treated properties such as this in this zoning district, in the face of urban renewal plans that may have a different direction or be at odds with what the outcome would otherwise be. But I think we have established pre-existing nature of the multifamily dwelling, the legal multifamily dwelling status of this particular property. And I'm a yes as to confirming the non-conforming density here. So I'm a yes as to the application.
I'm also a yes.
I'm gonna say this before I say that I'm a yes. I sat from beginning to end as a planning commissioner doing transform. It was a very volatile time in Baltimore, but it was the first time in 40 years that the city had taken a good hard look at the zoning in Baltimore. Urban renewal plans came into effect to help urban areas and community organizations get a chance to change stuff in their area. Massive law change, which Transform was to change the law in the entire city. And one of the things it targeted more than anything else was spot zoning. So if you have people in your organization, and Mark, you're very forward thinking, and you also have a great feel for the past, but if you had that and you're 20 years ago, knowing you see this train coming down the track again, that's when you fight the fight. Not at this point where people, I believe, where people are saying, there's a vacant property, I'm gonna go in and invest some money, I'm gonna go in here and build it up, and this is what I wanna put in it to make it work at all, because it wasn't working because nobody was buying it and keeping it. So therefore, Transform did its job, I'll say almost in total, for the city as a whole. And we see the changes going on now. And in a city that has population dwindle, not necessarily about adults, but more so about the fact that people are leaving the city and taking those bodies you count as kids to other places in the state or out of the state. And I think that's part of the problem we have, that we want us to be what we were in the 50s and 60s. Nobody stays in the past. Nothing changes unless you make it change. And that's what we did in the 60s. We made things change. So I agree with following the law because it's all we have to follow. But there were 40 years that we sat there with poor zoning laws and not effectively putting them in play in areas where we could have, especially in areas where we had strong community leadership. And I don't think you can cast that on this board because we've got to follow what the law says we have to follow. But I'm a yes.
I will also say a few words before I vote yes. I just want to encourage neighbors and legislators that have concerns with the law that feels in conflict with the values and their desire and their vision for their neighborhood to make sure that they understand that BMZA legally cannot always be the tool to walk hand in hand with you on that vision. And so legally, we are charged with looking at what has happened to that house. It's remained vacant, by your own words, Mr. Washington, because the community has come and opposed it becoming 3 units, or to remain 3 units, I should say. And that's a challenge of the neighborhood and the challenge of the expense of conversion based on the current appraised property. It's very difficult to convert a 3-unit building into a single family, and the cost may not equate with the current property value across the block. So while I am sympathetic and in agreement with a lot of the value-based or philosophical belief of what you want your neighborhood to look like and the passion and organizing that comes out of CHUM, we have to look at the law. So I am a yes.
Okay, thank you. Let's go off the record for about 5 minutes before we take up another the next case.
Off the record.
All right, thank you.
I'm only giving you.
Get back to the docket. We'll call case number 2023-180, 175 West Austin Street, MH Spring Garden LLC. Okay. Welcome.
Thank you. Good afternoon. How are you?
I'm doing well. Yourself?
Doing great. We
Great.
appreciate the opportunity to be here today. My name is Stephen Grenke, STEVENGROENKE. This is my partner, Jeff.
Jeffrey Osborne, JEFFREY.
Okay.
OSBRNE.
And you're here representing, sorry, I have a cough drop in my mouth. MH Spring Garden LLC, and the request is to add live entertainment.
That is
use
correct.
To an existing brewery, restaurant with outdoor dining and catering requiring conditional use approval. Is that correct?
That is correct.
Okay, great. Let's get these gentlemen sworn.
Hands. Do you swear or affirm that you tell the person that the answers that you give in the statements that you make will be the truth, the whole truth, and nothing but the truth?
I do.
I'll hear from staff and planning.
Okay, so the request that was submitted was to add live entertainment to an existing restaurant use with outdoor dining and catering requiring conditional use approval. The things that actually require conditional use approval is basically just the live entertainment. The restaurant is already there. Outdoor dining is allowed by right in this zoning district. Catering can probably, and the board can decide this, can probably be approved as an accessory use to the existing restaurant. The code is not very specific about catering, so that's how we've treated it in the past. So technically, and then off-street parking is not an issue because the use isn't, you're adding to an existing use, so the off-street parking wouldn't change. So, just to summarize, what we're here for is the live entertainment and catering as an accessory use to the existing restaurant.
Okay.
That's it. And I'll leave it there.
Planning Department has reviewed this application, has one very specific comment concerning it, and that is that it does not include a detailed statement relating to security. It states the staff is to be trained in crowd maintenance. There would be a doorman for special events. The department requests that the applicant provide the board with more detailed information in order to make the application approvable. Other than that, the department recommends approval of the application subject to these conditions. A copy of the use and occupancy permit for the premises must be kept on the premises and available for inspection by representatives of Baltimore City at all times. A copy of the written approval by the board, the live entertainment provided on the premises, including details of any restrictions or limitations on live entertainment provided, must be kept on the premises and available for inspection by representatives of Baltimore City at all times. And a copy of all other permits and licenses required pursuant to the written approval of the board must be kept on the premises and available for inspection by representatives of Baltimore City at all times. Thank you.
Thank you, Mr. French. Are you gentlemen in agreement with, or agreeable to those conditions stated by planning?
Yes, we are.
Okay.
I don't think there's an issue since it's industrial. It's not area.
Okay. What else can you tell us about, if anything, your security plan in connection with the addition of live entertainment, or what you have in place that you believe is suitable for the addition of live entertainment?
We're very committed to the community. I live in Federal Hill. What we have done when we applied, and to give you a little history of this location, back in 2017, it was actually developed by another Baltimore City resident, and they opened up a brewery called Checker Spot. And it's right on the intersection of Austin Street and Sharp Street, which if you're leaving a Ravens Victory and you go over the Austin Street Bridge.
As opposed to a Ravens loss, right?
Come on now, stay positive with us. We got to stay positive.
I'm good, it's all victory.
It's right on the right-hand side, and they operated a very successful brewery there in our community for 6 years that also included entertainment. They really put us under their wing, and because they were so successful, they expanded to a new location that's almost twice as large, and we successfully acquired their equipment in that existing location, and they've realized, hey, it is an economic impact on the city to have two breweries in South Baltimore. People in the local community like to go there. They've helped us with our brewing processes, understanding the technology, but also understanding the ropes and the commitment that we have to provide to ensure that we're following our liquor laws correctly, that we're carding and managing the complex. And one of the other things that the community said that they had was this entertainment. And Checker Spot has also helped us out to make sure we understand the requirements, and we can also provide the actual security plan that we will have for events. Now, this isn't going to be, your M&T Bank Stadium Billy Joel concert where you need that level of security, but we also understand if we have a birthday party for 40 people, we need to have the right people, the right staff, and we're committed to do that to manage this location correctly.
Okay, and so, first, the entertainment, the live entertainment is it going to be as needed or per project, or is it going to be 5 nights a week?
Two examples were, someone wanted a birthday party, they wanted to bring in a polka band or a jazz band. And it was about 50 people, and they had some friends that played in a band. And we said, right now, we've realized in our haste in September, we did not have that, so we said we can't allow that. But that's when this stimulated, hey, we should go back and apply for that. So we'll be on a special request. It's not like it will be call it like a venue type of an occasion for a birthday party or an office party if they wanted to have or add live music.
Okay. And so what you mentioned in terms of a security plan, you develop them with respect to the particular event that's coming along.
What we're committed to do is define a standard operating procedure for this type of an event that has live entertainment. And then I think we would, train and make sure the staff understands that procedure. But obviously, if there is some other deviation to an event, we'd have to modify or tweak that security plan. But one of the things that we've already trained all of our staff on the liquor license laws. They're certified, and we understand the responsibility that goes along with managing this type of operation. But we also are excited based on what the community has shared with us. We're in a TOD 4 zone. We face the west side, which basically faces Ravens Stadium. We're over 1,000 feet from the community, and we have access to 200 parking spots. So we're in the right location in that kind of southern community. It's not industrial, but it's not residential. But we also understand the requirements from a safety and a security standpoint.
With regard to the SOP for those types of events, have you developed that yet? Because the next question is going to have is, would you be willing to present that or append that to a potential approval as to this is the standard operating procedure we're intending to?
With an approval on that condition, we would absolutely, forward that plan.
Okay. All right, and I just have a question about your catering. As Ms. Witt indicated, catering historically, at least through the BMZA, has been approved as an accessory to the restaurant. I guess that's sort of occasion specific as well. You just do that as a extension of your restaurant business?
Correct.
Any questions for the applicants?
I have one, actually. Are you ever going to have live entertainment outside or only inside the building?
We have talked to the community because there has been live entertainment in the past, and they have shown an interest in that. So we think that could be a potential option as well in the future.
Outside?
Outside as well, yes.
Okay, and the next question is not for you, but for Ms. Witt. Does food processing light come in here at all?
No. I mean, if all they were doing was catering or some kind of commercial kitchen, then it would be categorized as food processing light. I think the code is not clear when it comes to catering. The liquor license often has catering as part of the liquor license, so sometimes people will put the same thing on their zoning application that they put on their liquor license application, and so that's why I think you can just, you don't need to worry about food processing light and just have catering as an accessory use. Maybe we can put that on the list for planning of their zoning code updates to make catering a little bit more clear.
All right. I guess final question with regard to the live entertainment, even though it's not maybe a regularly occurring thing, when you do have those events, is there a cutoff time which you're going to end the live entertainment?
We're licensed. We're licensed until 2 a.m. at the moment, and we would not be going anything over that time.
The application says 11.
Yeah,
I think 11 is the time
11's
for the
our
live
proposed for
entertainment.
live entertainment.
Okay, can we hold you to that?
Yes.
Okay. All right. No other questions? Thank you so much.
Thank you.
Okay. So we're here for the conditional use of the live entertainment. I think there's not really a question with regard to accessory use of catering, accessory to the restaurant business. So to the extent that requires a vote, I'm a yes as to that based on the presentation. But with regard to the live entertainment, I'm a yes. I would like them to add, as they said they'd be willing to do, at least some statement of their standard operating procedure with regard to security for the events that they hold. And I think that could be applicable across the board to the kinds of events they'll want to have. Based on the presentation, I don't see any evidence in the record that would suggest that adding live entertainment at this location would somehow be detrimental to or endanger the public health. And I do appreciate the description of where it's located and what's surrounding it. And that's exactly where we want something like that, it seems. The conditional use is not precluded by any other law. The authorization for it is not contrary to the public interest, and I think that the authorization for the requested conditional use would be in harmony with the purpose and intent of the code. And I do not believe there would be any more significant or greater impacts that would occur with this conditional use than would be applicable to any other location in the particular zoning district. So I'm a yes as to the live entertainment request, with the condition of the SOP being appended to their application and made a condition of approval, as well as the accessory catering.
Do we have to put a date on when it's to be submitted before the approval letter goes out? Should it be
Well, I
done that
think
way?
if
At
you
least
could
a
submit
draft.
that prior to, it's going to take a little bit to write up.
Yeah, so the draft resolutions will be before the board January 16th. So if you want to submit it before then, we can
It can be
include
incorporated.
that. Yeah,
Great.
We can do that.
thank you.
All right, so I'm a yes as to the requested.
I'm a yes.
I'm also a yes.
Also a yes.
Thanks so much. Thank you. All right, good luck to you. See you at the victory party.
Super Bowl.
Right, okay. Case number 2023-193, 1307 through 1311 West Baltimore Street. Ms. Tilden, welcome.
Hello, Drew Tilden of Rosenberg Martin Greenberg. I'm here on behalf of the applicant, and I'm joined by Mr. Winfield Willis and also Ms. Bria Burke from Colbert Matson Rosenfeld. And I'm just gonna come on around
All right.
while you swear them.
And while you're doing that, I'm going to, I guess, call the rest of the case. This is a request to construct a multifamily dwelling, 25 units, requiring rear yard and off-street parking variances. Okay.
There's usually two of us.
Yeah, there you go.
Thank you. Yeah, of course.
Handling business. And if we could get the party witnesses sworn.
Raise your right hand. Do you swear or affirm under the penalty of perjury that the answers that you give and statements that make the truth, the whole truth, and nothing but the truth? Can you state and spell your full name for the record?
Winfield Willis, Winfield, Willis.
All right, I'll hear from staff and planning.
All right, Ms. Tilden can correct me if I got this wrong, but I think there are two variances being requested here. Minimum rear yard, 20 feet required, 0 is proposed to be a 20-foot variance, and parking, 25 spaces required, 1 per dwelling unit, 0 parking spaces are proposed, so it'd be the full variance of 25 parking spaces for this project.
Planning Department has reviewed this application, notes that this property is in the Union Square Historic District. Ordinarily, the board would be requested to defer its hearing until approval by CHAP of the final plans for the building. In this particular situation, because of the property's dimensions, location in an historic district, and the issue of the parking, the design of the building could change radically depending upon any or all parking variance that's granted. Therefore, the department is actually supportive of this request in advance of actual CHAP approval, and recommends that approval of the application, if granted, be subject to the condition that the applicant then proceeds to obtain an authorization to proceed from the Commission for Historical and Architectural Preservation. Thank you.
Thank
And
you,
we
Mr.
accept
French.
that condition.
And you're agreeable to that, Ms.
Yes.
Tilden, your client?
Absolutely.
All right, very well. Floor is yours.
All right, great. Well, just to begin again, I'm joined by Mr. Willis from the applicant, and again, Ms. Bria Burke from Colbert Matz Rosenfeld. She was not yet sworn, but if you have any questions for her, she is available. I do want to quickly clarify that we actually reviewed this application, and we don't believe that we need the rear yard setback variance. I'll describe in greater detail once we get to the legal standards, but the property actually abuts an alley. It's called a street, but if you apply the legal definition of an alley, that's what I'm here for. When you apply the legal definition of alley to it, it's an alley, so there actually is not a rear yard setback requirement. So in summary, the applicant is proposing to consolidate the 3 lots, 1307 through 1311 West Park Heights Avenue, and construct a 25-unit multifamily dwelling with 2,700 square feet of restaurant space on the ground floor, and therefore requests a 25-space variance from the off-street parking requirements to provide 0 spaces. The property is located in the C2 district and is also located in the Union Square CHAP district. The property land area is a little bit over 5,700 square feet. It's located in the Franklin Square neighborhood and is on the south side of the block of West Baltimore Street. The 3 subject properties have actually been vacant for some time. And adjacent properties are all attached and they are improved by attached structures. This property has stood vacant for years and it's just leaving a gigantic gap between the attached structures to the east and west. As I mentioned, the applicant proposes 25 units. There will not be any off-street parking spaces and there will be ground floor restaurant space. We've engaged in substantial community outreach and have included letters of support from this Franklin Square Community Association and also the Union Square Association. I sent the Franklin Square in advance, but we just received the Union Square last night, so it's in your hard copy of exhibits that I've just passed around. So preliminarily, of course, we're requesting the off-street parking variance. 25 dwelling units require 25 spaces under the code and 0 are proposed. The code exempts the first 3,000 square feet of a building's commercial space in the C2 district from the code's off-street parking requirements. So the commercial space does not require any additional parking spaces. In terms of the alley is defined as a roadway that is open to the public and primarily designed for use as the servicing and designed and used for the servicing of adjacent buildings through their rear and side entrances. So if you take a look, I've got several street view images in your file. Booth Street is the public right-of-way directly behind the property. And it is, per the attached tax plat, only one residence actually fronts on Booth Street. Additionally, if you look at those street view images, you'll see that it is full of garages and other kind of accessory uses for the adjacent properties that front on West Baltimore Street. So for that reason, I believe that Booth Street qualifies as an alley and we do not indeed need to request the 20-foot rear yard setback variance. So I'm now going to go through the uniqueness requirements set forth in the zoning code. Preliminarily, the property is unique based on its physical surroundings. As I mentioned, it's located at the center of the block and it's surrounded by other attached structures. Also, all of the lots along that front, all of the other lots that front on West Baltimore Street span the entire depth of the block, and they don't provide any rear yard setback. Also, the tallest building on the block is 4 stories. So where the practical difficulty comes in there is that while the code permits a building height of up to 60 feet by right in the C2 district, it wouldn't really be appropriate for the property's improvement to greatly exceed the height of other buildings, so going all the way up to that 68-foot building height. We also believe that the building should span the entire width and depth of the lot to conform with the other structures on the block. The 25 units, as I mentioned, are permitted by right on the under the C2 district's 225 square foot per dwelling unit minimum lot area requirement. But to apply the strict letter of the code's off-street parking requirements would require that the applicant provide off-street parking on the ground floor, and that would result in a much taller building than would be appropriate. So I'll now go through the rest of the variance standards quickly. I understand that the board is busy today. So the conditions on which the application is based are unique to the property and are not generally applicable to other property within the same zoning classification as described above. The practical difficulty is caused by the application of the off-street parking requirements to the unique property. Neither the applicant nor any other party with a present interest in the property has taken or failed to take any action which is causing the practical difficulties from which this application arises. The purpose of this variance is to facilitate the redevelopment of the property for its best and highest use, especially considering its long-standing vacant nature. The variance is neither going to be injurious to the use of and enjoyment of the property in the immediate vicinity, nor will it substantially diminish or impair the property values. Please see the 2 letters of support that we've included in the file. The property is not within the boundaries of any urban renewal area. As Mr. French mentioned, this is located in the CHAP district and will be subject to design review. And it is not precluded by and will actually not adversely affect the city's master plan. It actually supports the plan's live element by creating additional housing units and also providing an urban and walkable amenity through the restaurant. Again, the letters of support demonstrate that this is not going to be detrimental to or endanger the public health, security, general welfare, or morals in any way. And for those reasons, the applicant respectfully requests that the board approve this application for a variance from the code's off-street parking requirements.
Question for Ms. Witt is, are we agreeable to the fact that there's no requirement for a rear yard setback?
Well, I think that's something for the board to decide, given what Ms. Tilden just presented to
Advised
you.
by the executive director.
Well, so
and
I
council.
can go through the legal definition of alley again, if that would be helpful to you all.
I take that and I frankly, I think I accept that. Yeah.
Right, so in C2, you either are required to have a 20-foot rear yard, or if you abut an alley, you're not required to have a rear yard at all. So they're saying that that is an alley, and if you agree, then they're not required to have a rear yard.
Yeah, it would be expedient to agree, but it'd be better to follow the evidence to confirm that it's actually not a street.
So the legal definition is primarily designed and used. If only one property fronts Booth Street, can we say it's primarily designed and used as an alley? Ms. Tilden?
Yes, so that is my assertion. I believe that because only one property is fronting on Booth Street, it's primarily designed and used, as you can see from the street views, to access the rear and side portions of other properties.
Looks that way to me. Looks that way to me.
Yeah, that's
Thank
what
you.
I'm seeing as well. So, all right. Any questions for Ms. Tilden?
No, I just have a statement that, in your cover letter, you have it as Park Heights Avenue, and it's read it as Park Heights Avenue.
Oh.
Check the record, it's Baltimore Street.
Yes. For the record, it is 1307 to 1311 West Baltimore Street.
Okay. No further questions, we can take it up. I would agree with Ms. Tilden's proffer that the Booth Alley, it's not a street, but it's an alley because it meets those definitions of an alley. And so there would be no rear setback variance requirement. And so the only one we're looking at is what?
The off-street parking.
Off-street parking, okay. Well, I'm also inclined to accept the proffer from Ms. Tilden with regard to the various elements of variances. It's also written for us very succinctly. And this is an effort just not to belabor the record. At pages 3 through 6 of the written presentation. And I would frankly incorporate those into a written finding. I think all the elements of variance have been established, the uniqueness, practical difficulty, and the additional requirements. As I said here, incorporate this written presentation into the record. Let me yes.
I'm a yes.
I'm also a yes.
Yes.
That's sufficient, Ms. Witt, or do we need to say?
No, I think that's fine, thank you.
Okay.
All right, thank you so much.
Thanks so much. Good luck to you.
Yeah.
Okay, 2023-195, 2219 St. Paul Street. Tom Fair, the appellant. Mr. Fair here, 2219 St. Paul. All right. We don't have any information from that applicant?
He signed in, so he may have stepped out for a moment.
Okay, well, we'll move on. Next case, 2023-198, 5513 York Road, Brandon Clinton. And this is a request to use the premises as a daycare center on the ground floor, healthcare clinic, first floor, and office space, second floor, requiring conditional use approval. Is that correct?
No, actually, we're going to file another appeal for the second floor as a healthcare clinic. The first floor is a healthcare clinic, so that's going to be done in a later date. So we're just working on the ground floor and the third floor as well. The second floor.
Okay, so you're here for the proposed.
The office
Care.
space, yup, and it's a day program more than a daycare center.
Okay, so the daycare and.
The office spaces.
The office space.
Yes.
Is that
Okay,
good?
sure.
All right.
So, sorry, is it my turn?
All right, let's get these gentlemen sworn.
Raise your right hand. Do you swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
Can I get your name and spelling first?
Brandon Clinton, that's BRANDON, Clinton, CLINTON.
And sir,
Lawrence Oluwagbemi. LAWRNCE, that's the first name, and the last name is OLUWAGBEMI.
Great. I'll hear from staff and planning.
Sorry to jump the gun there. So the office space is by right use. So we don't need to, the board doesn't need to consider the office space on the second floor.
Okay.
We are crossing out the healthcare clinic for now. Apparently that's going to be a separate application. So really what we're here for is the adult daycare center on the ground floor. So that's what the zoning code calls the activities that go on here, adult daycare center. That is a conditional use. And they are in C1, so they're exempt from parking. So there's no parking that the board needs to consider. The only thing I would just highlight is that the board has to find that there are adequate on-site drop-off zones and exterior lighting, and that the amount of traffic and noise would not be excessive. I think that's it for me. Thanks.
Thank you. Planning Department has reviewed this application. It notes that this is York Road. There is not a location suitable for drop-off or pickup of adults on York Road itself. And if 40 family members were to drive there all at once to do either thing, it could cause some serious issues with York Road. However, it's also possible there is an existing passenger loading zone associated with the religious institutional use of the property that was previously established. Harwood Avenue is designated as one-way outbound or westbound at its intersection with York Road, thus is not available for drop-off or pickup. The applicant is therefore requested to inform the board of how the days and hours of operation of the daycare center would operate and where the drop-off and pickup would occur. The department otherwise has no comment on the application.
Mr. French, can't hear you.
Serves me right. All right. Planning Department reviewed this application. Notes that this is York Road, which is a busy street. There is not a location suitable for drop-off and pickup of adults on the site itself. York Road, being a high-volume traffic road, could experience problems with traffic if 40 people were to arrive at the same time to drop off or pick up an adult. And unless there is an existing passenger loading zone already on York Road associated with the religious institutional use of the property that was previously established. Harwood Avenue is designated as one-way outbound or westbound at the intersection with York Road, and so is not available for a drop-off or pickup location. The applicant is therefore encouraged to inform the board of days and hours of operation of the facility and how drop-off and pickup would be managed. The department has no objection to the application. Thank you.
Thank you, Mr. French. So, gentlemen, in light of planning's comments, what can you tell us about the drop-off and pickup and drop-off location, whether you have another space that's not on York Road. Can you tell us about that?
Okay, so in light of that, we are an institution where we are funded by the state to provide services to adults who are mentally disabled.
Sure.
So we have residences that they stay at, and during the day, we kind of provide, this building would be their space for them to kind of do supported employment services. They want to find a job, kind of relaxing activities as far as movies. It's a day program. They have exercise rooms and stuff like that. So we have vans, we have sprinter vans that come to their units and pick them up and bring them to the day program itself. And across from the day program, across from our building, we have a parking lot that they usually sit in. And they can wait for us to, once the gates are open, they are let off the van and into the unit, just straight across the street. And the parking lot is about maybe 30, 40 spaces there. So that's kind of where we do our dropping off and loading. It's on Harwood. It's not on York Road, so we don't do anything on York Road. It's on Harwood, and we kind of just have them get off the van, walk directly across to the building, and that's how we do that. We don't really take up any space on Harwood at all. Usually when we have the vans there, they drop them off, they walk across, and then they keep it moving. And we also have a side lot as well, so they can come into the side lot and use that as well as kind of like a parking situation as well.
For clarification, do you own the parking lot on Harwood?
I believe we do. Don't quote me on that, but I believe we do. I believe.
That's an important.
Well, it's an important feature because let's say you don't own it and all of a sudden you don't have access to the parking lot.
But we've been using it for as long as we've been
I
there.
understand.
Yeah.
And there have been lots of uses that have been not legally authorized uses.
Right.
And so in order to, I guess, confirm or assure us that there is a viable and legitimate drop-off and pick-up, it sounds great that they can use that, but the issue is your authority to use it so that that continues beyond an approval, today.
Right.
And so
I strongly believe we own it. I don't have the
appreciate
papers
that
in front of me,
strong
but I do strongly believe it.
And just to add to what he said, there's a church building attached to the building that we're using. So and during Sundays or over the weekend, so most people come into the church use the parking lot, and I strongly believe that some of our clients that goes to the church program, they also park on it, and that's not never been an issue. So, which I believe that we actually own the parking lot. So,
let me be sure I understand what you said. There's the parking lot that you described, off of Harwood, which seems to be the viable way, the way you've always used it. That we have a question about, and you're suggesting that there's another location adjacent to the church?
No. So the building that we use it is attached to the church.
Okay.
We're in the back. We're actually in the back of the church.
Okay.
And with that, the church on Sundays use that same parking lot for their
services.
Yeah, for their services, for people to come park and come over to the building. So he's saying that to kind of say that I think we do own the parking lot, because we use it, and we've been using it, for years, and we never got. I don't want to say we got any pushback, because we just was looking into it the other day, and there was another name on it on the parking lot.
That's interesting.
But it was.
Thanks for telling me that.
Yeah. But it's. I don't know if they're in conjunction with us or not.
We don't either.
Yeah.
That's the point.
So I think the issue is, so there's actually two parking lots, right? So there's
there's one that's attached to the actual building that we have, that we know for sure. It's like right on the side of our building, and it's kind of like maybe like a space that we kind of park our vans on and stuff like that. That's where we have our sprinter vans and stuff like that, and it's gated. So we lock that gate at night and have that. But we also have the Harwood parking lot that's right across the
So
street.
put aside the Harwood parking lot,
Yes.
whose ownership we haven't yet established.
Okay.
Oh, I see.
The parking lot where that's gated that you're referencing, is that suitable for pickup and
Yeah, we
for
can
drop
pull
off?
out. Yeah, because a lot of times we pull our vans into that, and it's a walkway right into the building that they can just kind of they wouldn't even be on the street or in the community at all.
It's right behind the church, basically?
Yes.
It's like a house behind the
Yeah.
church.
Yep.
So you're in the back of the church, and then there's a house, and then there's this kind of alleyway parking lot area.
It's all kind of in the same.
Okay.
Who owns the house? Do you know?
We do.
Oh, okay.
We're actually renovating that house to make it a unit to have some of our individuals in there. We're building it up now.
Okay. So,
And which way do you go? Can you pull in and turn around, or can you go little?
Yeah, you can turn around in there.
You
It's
can't go
wide
through.
enough.
Can
No,
you?
you can't go through. It's a gate at the back
so
of it.
that's the length of a car. So yeah, you could turn around. Okay.
All right. Okay. What about the lighting around there? Do you have lighting in the back of that area where you indicate that you could use as a parking?
Yeah, we actually have street lights in the garage and on the actual the hardwood side of the street where the house is on.
Yes, sir.
And we have lighting in the building, like when you kind of walk into the space where we enter our building, we have a big white light up there as well. So the area we're in is pretty lighted with various devices.
Okay. So the drive that you're intending on using for 5513 looks like it's in the plot of 505,
Exactly.
which you own.
Yes.
Okay.
Operating the daycare center there, what can you tell us, if any, about any additional noise that might be generated at that location with this daycare activity?
Well, as of right now, we don't really make too much noise. It's usually an in and out situation. They're there at
I like
9
the way you're
o'clock.
qualifying.
They're there at 9 o'clock and they leave at 2, so we're there before it's dark.
Okay.
I mean, they're gone before it's dark.
9
The
to
office
2.
closed at 5. The most that our individuals may be in the community is to go to like a Stoko's or like a convenience store. Wendy's is right there to go get something to eat. Other than that, they're usually in the house. I mean, they're in the building. They go out into the community, into the neighborhoods. There's a rec center that they go to down the street. The neighborhood is pretty familiar with them. We actually just we was in a meeting with some of the community planners to talk about getting them jobs in the community and having them do various things in the community. So that's pretty much the most impact we have as far as making noise in that neighborhood.
Okay. And is this 5 days a week, Monday through Friday?
Yes.
Okay. From 9 to 2?
Yes.
Okay. And that rec center, you said that they utilize would, I guess, satisfy your state requirements of having the open space and recreational areas that they need to have as daycare?
Well, yeah.
All right. Okay. Any questions for the applicants?
No.
All right. And this is for up to 40 people, is that correct?
Yes.
All right. All right. Thanks so much. Go ahead and take it up. So we're here on the conditional use for an adult daycare, 40 individuals. Primary issue seemed to be assuring that we have an appropriate pickup and drop off. And as my colleague stated here and identified, based on the presentation, there is an area that can be utilized for that drop off and pickup solely within the property lines of this particular property. It looks to be satisfactory. In addition to the fact that you may have another parking lot that you've utilized historically that you may or may not own, but that could be a backup for purposes of what we have to confirm here.
I'm like 85. I'll say 90. I'll throw 90 in there. I'll throw you a good 90.
It's all right. It's all right. That's not necessary. We don't have to have FanDuel level probability.
There you go.
Okay, so I've not heard or seen any evidence that the particular use requested the daycare would be detrimental to or otherwise endanger the public health and safety or welfare. I think it'd be just the opposite. It's a location apparently for which there's a need that would be beneficial to the community and a portion of the community, and certainly the population of the residents or the participants in the daycare program. The conditional use is not precluded by any other law, including any applicable urban renewal plan. I think the authorization for this requested use would not be contrary to the public interest, but would be consistent with it, and that the authorization would be in harmony with the purpose and intent of the code. And I also believe that any impacts to the community as a result of this requested use would not be over and above what those impacts would be at any other location within the particular zoning district. So I'm a yes to the application.
I'm also a yes.
I can say yes.
Yes.
Thank you so much.
Thank you, guys. Thank you. Appreciate it.
Okay. We need to go off the record. We're going to have to go off the record for a few minutes.
Off record at 3:33.
Is there a Tom Fair here?
Yes.
Okay. Hey.
Board's indulgence to be heard.
Sure.
Before the two, there's two variances with opposition.
Sure.
One is a conditional use with no
Okay, which case is it?
210.
Oh, yeah. We got you, Ms. Stoll.
Thank you very much.
Gotcha.
I may have to postpone one. I've just got a little personal emergency childcare thing that looks like I'm not going to
man
be
wanna joust
up
today.
before it is. Do you want me to send you an email and kind of
Right.
put that on the record?
Yes.
I can have
Yeah, Mary Pat is visible everywhere. Do what you got to do. Well, you know, but that's all right.
Mr. Chair, may I request that we turn this thermostat down?
Oh, yeah, it's kind of hot here.
I'm dying.
Did I get the control out? I'm gonna snap.
I don't know. Where is it?
Behind.
Yes.
The board votes to turn that down.
Absolutely boiling.
Thought it was just me.
No, I can feel like my cheeks.
There was a complaint about the very same thing a few days ago.
Yeah, yeah.
And I was like, well, it's the first time in a long time.
My mother-in-law must have been in here. She
I was about to say, it's
being
how often is
inferno.
that?
You shouldn't have said anything, Mr. French.
Put him up? Okay. Oh, okay, okay. Yep. Yeah, you mentioned that you were hoping that Nate might be able to help him along, but looks like they're aligned anyway.
Intro 206, then 210, then
Okay, yeah.
206 for a postponement,
Mhm.
210 for the quick one, and then also somewhere in there is the fair. It's
Yeah.
got the really easy.
He can come back. We'll pick him up after this. I don't know if we emptied the room or not. Because I don't even see Nate. Oh, he's back there? Okay.
We back on the record?
Okay, we're ready to go back on the record.
We are back on the record at 3:36.
All right, calling case 2023-206, 840 Lemon Street. The applicant is, the appellant is David Akinyi, and represented by Nate Prettle. And Mr. Prettle, this is a request to construct a three-story building to use as a multifamily dwelling with 4 dwelling units, requiring minimum lot area, maximum lot coverage, rear and interior yard variance. And I believe we're here for postponement request?
Yes, if the board would be kind enough to grant the postponement, there's several reasons. One, I have an unexpected sort of personal emergency this afternoon, but also, we had a community meeting last evening with one of the associations of record, and it is, the postpone would allow us to get some communication on the submitted from, frankly, a couple different associations, and to have the property owner who is out of the country, sort of some pre-wedding preparation, will likely be back as well. And I think it may be more appropriate just to have all of this stuff rather than me speak to what we may have, have it all on the record.
No, we appreciate that and certainly encourage all that communication prior to coming to us, so.
I think there is one person here in opposition.
Yeah, who is that?
Myself.
All right, sir. Typically, when we do get postponement requests, because of the reasons that.
I know why.
Yeah,
know most of
okay.
that. I'm in an association, but I don't use that.
Okay, got you. That'll save some time. Any objection from the board for a postponement request?
No.
All right, granted, and let Ms. Witt's office know when you're ready to come back, and we'll get it back on. Thank you, sir. Oh. That was 206. We skipped ahead because we knew he wanted to postpone. Oh, okay. Yeah. Okay, we'll get him in just a minute. Thanks, Mr. French. All right, now going to call, and we're taking these cases a little bit out of order for some sort of extenuating reasons. Calling case number 2023-210, 1239 Druid Hill Avenue. The appellant is Beloved Community Services Corp. And this is a request to use the premises as a government facility requiring conditional use approval. Welcome.
Thank you.
Ms. Dolzall. We could get the parties and witnesses sworn?
Sorry, one more coming.
Okay.
You swear or affirm under the penalty of perjury that the answers that you give and the statements that you make will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes. Thank you. And ma'am, if you could state spelling.
Sure. Alyssa Domzal, ALYSSA, DOMZAL, Ballard Spark. I don't know if you, are you swearing everyone in?
I just did.
Okay.
Yes. If you step up and speak, if you could please state and then spell your name.
You want her
testimony now?
No. We're gonna go get some. We'll get your spelling of your name and so on and so forth if and when you need to speak. Right now, we'll go to the staff report and planning report.
Okay, so one request here, which is for conditional use approval for a government facility, which is not one that we get very frequently. It's structure or land that's operated by a government agency, including agency offices. So the proposal here is for the University of Maryland, Baltimore to operate the center that's going to be located here. I will leave it there for now because I'm sure Ms. Domzal has more information for us.
Planning Department has reviewed this application. We also spoke briefly with Ms. Domzal about this. We were concerned about what was on the floor plans, the possibility that it suggested there could be use of the property as a healthcare clinic.
Yes, sir.
Which is not a permitted use in this R8 zoning district. However, we've been reassured that that will not be the case, and the department is therefore recommending approval of the application.
Thank you, Mr. Frank. Ms. Domzal, go ahead.
Thank you, Mr. Chair, members of the board. Alyssa Domzal with Ballard's Bar on behalf of Beloved Community Services Corporation, the applicant. We are here, as I mentioned, for a conditional use approval for government facility offices in an R8 zoning district at 1239 Druid Hill Avenue in Upton. The proposal is to rehabilitate an existing historic row house for use as the University of Maryland, Baltimore's ROAR Center. ROAR stands for Rebuild, Overcome, and Rise. It is devoted to providing holistic, client-driven services to survivors of crime in Baltimore City. With me today is Dr. Al Hathaway, Executive Director of Beloved Community Services Corporation, the champion of this project, and Lydia Watts, the Executive Director of the ROAR Center. They can explain more about the project and the building's rich history. Certainly Lydia can explain more about the programming, but I do want to address planning's question. The floor plans say community clinic. It's a legal clinic, like expungements, that sort of thing. It's not a healthcare clinic. So that was just a misunderstanding. There's no healthcare. Again, Lydia can speak further to this, but there's no healthcare services provided at the center whatsoever. With that, Dr. Hathaway, would you like to explain the project?
Yes, Dr. Al Hathaway, AL, well, full name since we formed, AL Alvin, ALVIN. Hathaway, Hathaway, and I'm blessed to be a senior. Beloved Community Services Corporation was created in 2008 to be culturally sensitive, culturally relevant community economic development. And we set out on a path to restore historic properties in Upton. This December 31st, we're going to complete the restoration of the elementary school attended by Justice Thurgood Marshall at 1315 Division Street, a $14 million investment. This follows that. This investment is about $2.5 million of a significant property honoring a significant woman in this community. I grew up in this community, have labored at the disinvestment in this community, and we are now fortunate to make investment in this community. Juanita Jackson Mitchell is an unsung hero. And so as we look to redevelop this, we wanted to make certain that it was consistent with her legal redress, her legal history. And so we partnered with the University of Maryland, Baltimore, more specifically with the University of Maryland Francis Curry School of Law, because we wanted to continue a legal use in that building in honor of Juanita Jackson Mitchell, first African-American female to graduate from the University of Maryland School of Law. And I think that that this follows with what our purpose is, but more importantly, I think it's going to be a tremendous testimony to this community that a property that has been vacant for more than 25 years will now have a significant investment and will become a beacon and will set the standard for restoration in this community. And so with that, I will stop and have Ms. Lydia Watts come and just tell you more specifically about her amazing program.
Thanks so much.
Good afternoon, Lydia Watts, LYDIA WATTS, and I am the Executive Director of the Rohr Center. We are a project of the University of Maryland, Baltimore, so that is our home, but we operate more akin to a legal services program or community-based organization. We, as was stated, we provide supportive services to victims of crime in Baltimore City. We've been in existence, well, I started almost exactly 5 years ago, but we started providing services 4.5 years ago in June of 2019. And to date, actually by the end of 2022, we had helped over 500 individuals and their families here in the city. About over 70%, between 70 and 75% of the folks who come to Rohr are survivors of gun violence, either parents or loved ones of people who have been taken by homicide or survivors of non-fatal gunshots. We were filling an incredible void in the city by providing that service. There has been expansion of services to that population in the last few years since gun violence has been getting renewed investments from government entities, so there has been some expansion. But when Rohr first started, we were the only program, a community-based program, not hospitals, that provided this kind of supportive services. The excitement we have in partnering with Beloved Community Services Corporation is, again, to honor the historic nature of this building, as well as the woman who practiced out of that building, Juanita Jackson Mitchell, as Dr. Hathaway stated, the first Black woman to practice law in the state of Maryland, and a civil rights leader here in Baltimore City. So me and my staff are very, very excited to be able to move our operations off of the campus where we're currently located and be firmly in a community where the issues that we are able to address, are unfortunately too prevalent. In terms of the services that we provide, we will be at a staff of 18 on January 2nd, 6 lawyers, 2 paralegals, 3 case managers, 2 therapists, and we do have 1 registered nurse on staff, but she does not provide medical services. She's a nurse care coordinator, so her role is to help folks that have either fallen out of care or never enrolled in care, either for chronic health conditions or something more acute related to their victimization, to connect them with the medical providers in the community that best meet their needs. So we will not be providing any medical services. Again, the clinics that we envision, the community clinics as noted on the floor plan, is it's a room that we hope to really use as a way to open up to the community, but it would be to provide legal clinics, which is why the term clinic was there. But we also, our two therapists also conduct what we call peer healing circles, which are sort of support groups for people, again, who have been directly impacted by gun violence. So again, no medical care, but we do have the holistic wraparound with the social work care, the RN connecting people to care, and then our legal staff.
Wonderful, wonderful. Well, just a question, will it provide clinical opportunities for the law students at the school?
Yes, we do. It's, we're not a designated clinic where a law student can appear in court, but we do have interns and externs from the law school, as well as from the School of Social Work, who do their clinical placements with us.
So just a point of pride from the University of Maryland School of Law. Back in the late 80s, I think as a first year, participated in the landlord-tenant clinic, which I think was very successful there. And I think did a lot of good in the community. So,
if I may add, this will be a companion to the work that will occur at the Justice Thurgood Marshall Amenity Center, where we will have housed there the Judge Alexander Williams Center for Education, Justice, and Ethics. So this will be a robust activity that will involve legal redress, will involve legal services and legal support that will occur in this community.
Great. Look forward to it. Okay.
And I just wanted to add to that matter was before the board, I think 2 years ago, for a conditional use for, and so now, thanks to the board, we're able to sort of continue this type of community use in Upton.
Wonderful. Okay. Any questions for Ms. Domzo? All right. Thank you for your presentation.
Thank you.
So with regard to this requested conditional use, don't see any evidence in the record that the requested use would be detrimental or in danger of public health. It's sort of completely the opposite. Certainly beneficial, needed, filling a void as indicated. And certainly there's no other preclusions for this use, not by law, by any urban renewal plan. It's certainly in the public interest to believe and in harmony with the purpose and intent of the code. And whatever the impacts are, I think they can only be good, and certainly would love to see it in other areas geographically in the city if we could find that, because certainly the city could use it. So I'm a yes for this conditional use.
I'm also a yes.
Yes.
I'm a yes.
Thanks so much. Okay. Case number 2023-195, 2219 St. Paul Street. Tom Fair is the appellant. Welcome back, Mr. Fair. This is a request to use the premises as a multifamily dwelling, one dwelling unit per floor, requiring off-street parking variance. Is that correct?
Yes, sir.
Okay. And how many floors is this building?
3.
3 floors, 3 dwelling units. All right, let's get Mr. Fair sworn.
Do you swear affirm that the penalty is perjury that the answer that you give is the same, the truth, the whole truth, and nothing but the truth? I do.
All right, I'll hear from staff and planning.
Okay, so this is an off-street parking variance request, 1 space per dwelling unit. The request is to go from, I think this property was used in its entirety as an office in the past, and now it's being, I won't say converted, it's being changed.
Can't use that word.
Changed to 3 dwelling units from its former office use. So every time you add a dwelling unit, you have to add a parking space. The interesting part about this application is that with the application was submitted a completed parking exemption for historic structures, which the head of the planning department already signed. So under the zoning code, there's kind of 2 avenues to get around the required parking. There's a parking variance from us, and there's a parking exemption for historic structures, for structures that are older than 50 years, which I would say most structures in Baltimore City are older than 50 years. So you can get an exemption from the planning director for that. So this applicant already has that, but for some reason, at zoning administration in housing, they sent him here for a parking variance as well. So this is kind of a belt and suspenders situation. He already has a parking exemption, but we're here. So I think that's it. There's also letter of support from the Old Goucher Community Association. One thing in their memo, I'll let Mr. French give his report, but planning does say that there's room for parking spaces on the premises. So that might need to be, need to be a question about that, but there is already an exemption on the record that we have.
Yeah, thank you. Planning Department reviewed this application, noted that this property is located in the Charles and 25th Urban Renewal Plan area. That urban renewal plan does not prohibit the proposed use of the property. The department also notes that this property was rezoned, along with its whole block, from OR, office residential, to R8 residential, and therefore the proposed use is in fact exactly consistent with the intent of that rezoning, which was to go back to full residential use and not mixed office residential. The department requests that the board, in approving this application, make it conditional upon use of the property complying with terms and conditions of the Baltimore City Code, Article 23, which is the sanitation code. And we'll leave it at that. Thank you.
Okay. Mr. Fair, is that compliance with Article 23 agreeable to you?
I'm a little new to this. Can someone explain?
Okay,
to
what
me?
the sanitation code is, basically to take care of your trash in accordance with the zoning laws. You could get some further explanation if you'd not get it.
Well, not being part of that department, I can simply read the citation which we have in our report. The sanitation code requires that there be for each dwelling unit's resident a designated container. There be a place near the rear alley for storage of such containers, and that the owner, if the residents generate more garbage and trash than the amounts allowed by the Department of Public Works, has ordinarily removed on a weekly basis, the owner is prepared to and required to get a private hauler to take away the trash.
Yes, we can do that. Thank you.
Okay, great. And I guess one question for Ms. Witt. You mentioned there are two avenues we could go. You could go the variance route or the exemption, which the gentleman, Mr. Fair, already did. The board is permitted to recognize that exemption?
I believe so. In my reading of the code, there's just two options, and you can do either one, and he's already done one of them. So the board could just say, hey, you've already, like from our perspective, you have an exemption already. Or you can go through the variance standards too. I asked zoning administration if they really meant to send it to us or if it was a mistake, and they said, no, he needs a parking variance. And I pointed out that he has a parking exemption, and they didn't respond to that. So that's why we're here, I guess. The board can decide what to do with
Sort of at
that
the risk
information.
of requiring him to go back if somebody doesn't accept the fact that what we told you to get, which is a parking exemption, and you got, requires also a variance within that. I don't know. I don't have the application in front of me. Are you prepared to walk through uniqueness and various issues
Yeah, can you
associated
tell
with
us
parking variance?
how much parking space there exists behind the building? Is the building completely take up the lot?
It's obstructed by a telephone or utility pole and by a fire escape in the rear.
Okay.
Very difficult to get parking back there.
Okay. You're not in the business of removing telephone poles, are you? Safely and legally? All right. There's some, okay. I find that the property, I'm sorry. Anything else you want to add? Okay. There are a couple things. First finding is that the applicant received a parking exemption, which should vitiate the need for us to go through this process. So on the one hand, I would say there ought to be a yes to this application because he does have the exemption. But in furtherance of that, the with regard to the variance standards, I believe the property is unique in that apparently where he would otherwise park, or parking would otherwise be available, there's a telephone pole which precludes that. I think the practical difficulty is sort of evident on its face with that kind of geographic structure there, and that would preclude parking. So I think there is a practical difficulty that's not caused by any action or inaction of the applicant. And let's see, what else? The purpose of, no. Just ask you the question. Open the testimony back up. Is the effort to obtain this variance based exclusively on a desire to increase the value or income potential of this property?
Well, the community voted to have apartments here rather than a vacant office building. Certainly, there's some financial incentive for the owner too.
But it's not based exclusively on that desire to increase.
No, sir.
All right. Well, there's a need. The community doesn't want a vacant building. There's a way you can develop it for use. And certainly revenue generation is a byproduct of that, but not the chief desire. I'm not testifying for you, I'm just paraphrasing what I'm hearing. So I believe we can find on the record uniqueness, practical difficulty. It's not caused by, it's caused by the code and not caused by anything this gentleman, any action or inaction of the appellant. Purpose of the variance is not based exclusively on a desire to increase the value or income potential of the property. I don't believe the variance request would be injurious to the use and enjoyment of any other property. Somebody could maybe use it if they remove the telephone pole, but again, it's not going to do that. The variance, I believe, is in harmony with the purpose and intent of the code. Should be in harmony with the other provisions, like getting a parking exemption, so we can avoid this whole thing. But the variance would not otherwise be detrimental to or endanger the public health, safety, or welfare, and I don't believe it's contrary to the public interest. So I'm a yes to the parking exemption being allowed to get a yes for this board, but any alternative that he meets the test for parking variance. So I'm a yes.
I'm also a yes for the same reasons.
Yes.
Yes.
Thanks, sir. Good luck to you.
Thank you, folks.
All right. Case number 2023-204, 1701 Edmondson Avenue, Nathan Gorham. Oh, sorry. Hold on, Mr. Gorham. Just getting some water?
Just
You
getting
good?
some water.
Okay, I'm sorry. Come on up. This is a request, Mr. Gorham, to use the premises as a multifamily dwelling with 3 dwelling units, requiring confirmation of non-conforming density. Is that correct?
Yes, sir.
We heard a little bit about that today, didn't we?
Yes.
Okay. Can we get Mr. Gorham sworn, please?
Do you swear or affirm under the penalty of perjury that the answers that you give, the statements that you make will be the truth, the whole truth, and nothing but the truth?
I do.
All right, here from staff and planning.
Okay. Again, request is to use the premises as 3 dwelling units, a multifamily dwelling, requiring confirmation of nonconforming density. The board approved 4 units in 1953 and then reduced that to 3 units in 1960. And I believe that's the last use and occupancy permit that we have on file. And just to point out, there are some photographs of the renovated property. It's been renovated for use as 3 dwelling units that are in your packet. So if you want to take a look at those photos, it looks like this property is ready to be inhabited as soon as they get their UNO.
Okay.
Planning Department reviewed this application, noted that this property is located in the Harlem Park 2 Urban Renewal Plan area. That urban renewal plan does not prevent or restrict the proposed use of the property. The department does note that if there was an additional dwelling unit required, none meeting zoning code standards could be provided because this property is only 16 feet wide, and an off-street parking space accessible from Mount Street would not be of sufficient depth to meet the 9-foot by 18-foot dimensional standard for a vehicular parking space. The department requests that, should the board approve the application, it be made conditional upon the applicant operating the property in accordance with the terms and conditions of the Baltimore City Code Article 23, which is the sanitation code. Thank you.
Okay, sir, are you agreeable to the application of, or the condition of Article 23 sanitation code?
I am.
All right, wonderful. Are you aware of any information different than that this was used as and legally utilized as 3 dwelling units, at least as far back as 1960?
No, sir.
So your information that it has at least been a 3 dwelling unit for duration. If not 4. Okay. All right. Any questions for Mr. Gorham?
No questions.
All right. Thank you, sir.
Thank you.
I believe based on the record before us, specifically the record presented by staff, that units are separately metered. This premises board did approve 4 dwelling units in 1953, and the board approved 3 dwelling units in 1960. That we can resolve this on a confirmation of non-conforming density. So I'm a yes.
I'm also a yes.
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 Thanks, sir. Good luck to you.
Thank you.
2023-205, 3407 Elgin Avenue. AB Associates. All right, good afternoon, Mr. Berry. This is a request to use the premises as a multifamily dwelling with 7 dwelling units requiring off-street parking. Is that correct?
Yes, with a clarification, just to, I'll
Okay.
get into that.
All right, and do we have folks in opposition? Okay, you go ahead and stand up so we can swear you all at one time.
Here is right hand. Do you swear or affirm? Do you swear or affirm in the town of perjury that the truth, the whole truth, and nothing but the truth?
I do.
All right, I'll hear from staff and planning.
Okay, so the current use of the property is as a multifamily dwelling with 6 dwelling units. They are proposing to add a 7th dwelling unit to the site. According to our calculations, this is all by right under the lot area. So we talk a lot about lot area and density. This is allowed under the density requirements. The only variance that's being requested here is for off-street parking. Anytime you add a dwelling unit, you have to add a parking space or get a variance. So 1 parking space would be required for the proposed new unit. 0 are proposed, so it's a request of a 1-space parking variance. In your notes, there's a mention of an alley in the back of the premises that could potentially provide access to parking spaces. There's been some more information submitted in the file about the grade of the property and why that might not be possible. So I'll let Mr. Berry kind of address that question of why another parking space on site can't be provided, and I'll leave it there.
Thank you. Planning Department has reviewed this application, has no objection to its approval, does request that if the approval is granted, that it be made conditional upon operation of this property in accordance with the terms and conditions of the Baltimore City Code Article 23, which is the sanitation code. Thank you.
Thank you. Mr. Berry, is your client agreeable to application of Article 23?
Yes, of course. Thank you.
All right. Go ahead, sir.
Okay, so as Ms. Witt said, this property is it's a very large, formerly single-family house. It's at the corner of Elgin and Garrison Boulevard. There is no off-street parking on the property, but the property does have, and we sent pictures, a very large and unique carriage house, 2 stories, that was formerly and has been improved for a apartment unit. In fact, the history of the property over 60 years has anywhere from 9 dwelling units on the property, including the carriage house, to the current 6 dwelling units that are in the main building. There was never any parking required for those units, so in that sense, by applying for this, reestablishing the carriage house unit, the zoning commission, or zoning administrator sent it to the zoning board for variance, which we're not disputing. Practically, the grade difference between the alley and the rest of the property, the rear of the property, would make it difficult to provide a parking space on the site itself. And in fact, the residents that there was a meeting with, you'll hear from them, were concerned about parking on Elgin. Elgin has apparently a parking issue at night. Our issue is that the carriage house, which is 50 feet from Garrison Boulevard, people will park on Garrison. They're not going to park on Elgin and walk all around the block to get to the carriage house. So we believe that there is sufficient off-street parking on Garrison to satisfy the parking needs. We also offered to the community, Mount Holly Association, that as a condition of the lease of the building, we would tell the tenant he's only allowed to have one car, it'd have to be registered, so we can track it. That would be a condition of the lease. Pavel Kazenkov is here. He's the developer of the property, can answer any questions. We think the building itself and the property is unique. The fact that the board can recognize that there is an existing apartment unit in the building, carriage house already, would be an unnecessary hardship, practical difficulty to not have that building reused and just kept vacant. There's been a suggestion by, I think, some in the neighborhood that the carriage house itself is set off the alley by, I think, about 3 feet at the most. And I think in a practical way, maybe whoever is in that building may try to park in that 3 feet, but they'll be blocking a portion of the alley. That'll be an enforcement issue for the city, frankly. But there's not enough space for a full width between the alley and the carriage house. We'll answer any questions that you have, certainly, and hear from the neighbors. But we do think it meets the uniqueness standard. It's a corner property. It has street frontage on Elgin that has parking where many of our tenants already park, and Garrison, which we think is a much closer alternative, a realistic alternative for the new unit in the carriage house.
And it's unique because of its size, shape, its location in relation to street.
Yeah, if one were to regrade the property, which you would have to do to get from either Elgin or the alley into the properties, there's a retaining wall in the back of the property now, that would present some difficulty in taking up the rear yard. If you were to put a parking lot off of Garrison, you would be removing a parking space that's there today for the community. So, and it would also be, somewhat distant from the carriage house in and of itself. So we're here today just for the parking that's required for the carriage house, not the existing units. I know there's some complaint about existing tenants, which we'll hear from the community about.
Okay. Any questions for Mr. Berry at this point? All right. Okay, folks. State your name and.
Tracy, T-R-A-C-I, Johnson.
Can you please turn on the microphone? It will be green when you press the button. There you go.
Okay.
And speak
Tracy,
into it.
T-R-A-C-I, Johnson, J-O-H-N-S-O-N.
Marcus Beckwith, Marcus, M-A-R-C-U-S, Beckwith, B-E-C-K-W-I-T-H.
Okay, either one of you, feel free.
Just parking. Parking is bad. It's terrible. It's about 16 cars roughly right now, and if they add the other unit to it, it's going to make it worse. My neighbor just told me that if they do park on Garrison, that's a bus stop, so there is no parking there for them. So I'm just against it, It's too much. They did say something about limit them to 1 car per household, but I don't know if that's something that they can legally do. They can say that and put in the contract, but if they can they legally do that?
Sure, you can make it a contract term of lease, and you'd be in breach of the lease if you violated that.
I didn't know if that, yeah, okay, cool. Well, I mean,
So if you had 7 units and you had 7 vehicles coming from, at most, from that location, sounds like that would,
That wouldn't be a problem.
That wouldn't be a problem.
The problem is what she's saying, and as I explained to them, I think they looking at value over our own sanity. He's talking about grading, meaning they don't want to pay the cost of making a parking lot back there for that house. I do a lot of work for landlords, and know about my brother is a landlord. And I know in contracts, you can also add those stipulations in when you move into cars about amount of cars and where they're parking and things like that. And like I was explaining to him, you have tenants in those houses, in those apartments that have 3 cars. Some of them bring cars and just leave them there, and they're, like, we have street cleaners. The street cleaner can come and clean up, and it's mainly my house. I have to come out and clean the whole neighborhood up because those tenants don't want to move their cars. And then I'm the only person in my neighborhood that has a driveway. I can't get out of my driveway because the tenants will block her in, so she can't get out of her parking space, and I can't get out of my driveway because the cars are here in my driveway, and I gotta wait for them to get up in the morning so I can go to work. One morning I come home, she had to back up her partner's car to get out of a driving space because where I park at, I like when she's parked there because nobody parks in front of her.
Do you
Usually
live
parks in front of her.
at the location?
Next door. She lives
Okay,
next door.
right next
She's
door.
my neighbor.
You're at 3405?
No, 8, I'm 10.
8 and 10.
Okay.
So when she parks there, if she's not close enough to the curb, in front of my curb, they'll get in front of her. So now she's blocked in and I can't get out. And the car, I have to wait for those cars. And like I was telling him, I personally spoke to the tenants myself. Asked them, I let them know, street cleaning comes. I had got a ticket before. So I try to tell them, park your cars the right way, turn your cars to do this, and it goes unheard. If the trash guy comes to Mondays and Tuesdays. Mondays and Fridays. They won't
Wednesday,
move.
Friday.
Trash day comes, they have the trash supposed to come out at a certain time. The trash sits out front. I'm not saying the neighbors throw the trash there, but it's a windy day or somebody blows trash. I have to clean it up. They say they have somebody that's a groundkeeper, but I have to clean it up. The reason I clean it up because I do that for my neighborhood. And at the same time, I don't want to have to clean up for grown people that's not taxpayer. Not saying not taxpayer, but don't have the same value that I have in my neighborhood. So when I come home, reason I got a parking space because I value everybody's space when it comes to my neighborhood. When I have family comes to my neighborhood, they park in the back alley in front of my garage. So nobody argues about space. I've been around here for 18 years. Never had a problem. Even before that building was occupied, before it became vacant, because the young lady lost the house. But it was people that were there before them that also respected our space. They parked a certain place. They even parked on our side. We didn't mind that. The people in the apartments, understood and respected each and everybody's space. And that's the main thing we're here to say. I understand is they're into business because I'm in the same business that they're in. But at the same time, you can, like I told them, you can put guidelines to control the problems at your property. And our main thing, and I know I'm going on because I'm ready to go home myself. But our main concern is respecting our property, our space. I can care less about the trash because I clean up. There's something for me to do when I'm doing it anyway. But at the same time, if the street cleaner comes, I don't want to have to clean their side, and it's the street cleaner's job. So now I'm having to do the street cleaner's job because your tenant didn't want to get up.
So you're saying if there was a condition of one vehicle per dwelling unit, that would.
It would
that
definitely,
work.
it would definitely help.
And Mr. Barry, I know this has already been a 6 dwelling unit property, and to add one, I don't think they're talking about that additional one agreeing to just one vehicle, because you have the other issue, I guess, of the folks who are already there. Parking in excess may be creating an issue. Is there any appetite for having a one-to-one dwelling unit to parking space?
Well, they're large units.
Yeah.
We discussed that with the community, and frankly, this,
That one bid
the first we heard about the complaints that the tenants were, they had parking in front of people's houses, which, you know, it's a public street in and of itself, but we gave the email of the owner to the community association. We will talk to the tenants about respecting where they park. We can only agree to, since the application is only for the additional unit, we can't agree to an existing unit, existing building, which has 2 and 3 bedroom units, to limit it. But we are willing to limit it to the carriage house as a condition of the lease. And if for some reason, and they have to register the car, so we know what it is. If there's somebody who's parking there that's not, they could be subject to termination. I think that's the most we can do. But we can talk to the tenants. We just became aware of it at the community meeting this week. We do think that if you look at the frontage of the property on both Garrison and Elgin, if somebody were to take the position, well, I just want people to park in front of their house and not my house, there is more than enough parking on Elgin and Garrison to park. If people are misusing, I mean, we can't force people to park on one side of the street or the other, just like people in the block could park in front of our building. We do think it meets the standards for variance. Again, the property was zoned at one time for 9 units. The carriage house has an existing apartment in it.
Do you know what period of time that was, that it was zoned
Yes.
for 9 units?
Yes, the, beginning in 57 to 1960, there were 9 dwelling units. In 60 to 63, that was reduced to 6. 63, there was a permit for 7 DUs and 1 rooming unit. 63 and 64, there were 6 dwelling units and 4 rooming units. In 65 to 93, there were 7 dwelling units and 2 rooming units. 93 to 1, 7 dwelling units and 1 rooming unit, that's 8 units. And then the last permit that Mr. Kaldenkoff received was for 6 units in the main building. So the zoning, as your staff mentioned, does allow the density by right for 7 units. We want the 7th unit in the carriage house, which is vacant, should be rehabilitated. It's a beautiful historic structure, if you looked at the picture. You know, if it was easy to put in a parking space next to it, on either side of it, but there's retaining walls, and it would be substantial grading to pull off the alley when you have Garrison Boulevard 50 feet away.
They don't use Garrison.
Garrison isn't a parking,
Yeah.
nobody parks on Garrison, it's a bus
Well,
stop.
there are no parking restrictions on Garrison, so I.
So let me
The
ask
bus
about
stop.
that.
You can't park on a bus
You
stop.
can see
Go back to
the
Garrison.
Garrison. You're saying it's a bus stop.
It's a bus stop right there on Garrison.
Well, typically the bus
Corner of
stops,
Garrison and Elgin,
Huh?
on the corner of Garrison and Elgin.
Yes.
and is your contention that there can't be any parking on Garrison?
Nobody parks there unless you want to get a ticket, and then.
No. I understand
But
bus
then
zone, you can't park in violation of a bus loading zone, but are you saying there's no space?
So after the bus stop, it's the alley.
Right.
So you can't park in the alley, then next to the alley is the church. So you want to park in front of the church. Then after that is, you can park on Garrison on the side of going towards Garrison and Wind Falls. But again, it's 2-lane traffic.
Yeah.
Cars drive up on both sides of the street. So now you're impeding traffic.
Right turn on Garrison and then straight and then left on Garrison. So they can't park there.
Let's try and find this bus stop.
Yeah, I'm trying to find the bus stop.
The sign may be down, but yeah, it's a bus
It's
stop.
a bus stop
The-
right there
The street
on-
should be highlighted, the light.
Yeah, right on the corner.
Yeah.
Mhm.
Well, I'll ask the question again, though, but if there's a bus stop there, Does that negate all parking on Garrison?
From that area, from that part, nobody, well, I think down by the store, before you get to the apartments, that's the only parking you can do on Garrison and Clifton? Is that Clifton?
Yeah, that's
Garrison and Clifton, that's the only part you can park when you're coming around the turn. And once you come around there, everybody's in two-lane traffic. Right in front of the church, the bus stop, there's 2 bus stops there. One on
Windsor.
Yeah, one on Windsor and Garrison, and one on, Elgin and Garrison. Unless they moved it up.
It's technically moved. It's
They
on,
moved it.
it's between Glens Falls Parkway and whatever.
Elgin.
But
Elgin.
your point is well taken, I get it.
Yeah.
No worries.
And then this apartment complex right there, so they have to come in and out, so there's no way you can park right there. Then my neighbor's, he has a driveway to come out, a 3-car garage. You can't park on that part of Garrison because his house is right there, and he's coming out on Garrison. I don't see the difference whether they couldn't come out on Garrison.
So you weren't there in, I guess, it's been 6 units since '01.
I've been there since '01, and the 6 units that were there, I can name all of them. I don't know any 3 bedrooms, maybe 1 2-bedroom now,
Well,
but everybody was a
hold on.
1-bedroom.
Hold on.
Yeah, I can clarify that if you'd like.
Yeah, I'm trying to, when it was,
Certainly. You got it. First name Pavel, Pavel. Last name is Kazenkov, Kazenkov.
and so from, I take it from Mr. Berry's presentation, from 93 to 2001, there was 7 units in a dwelling, in a rooming?
That's right.
Well, from 93 to 2001, city permits downstairs said there were 7 DUs and 1 rooming unit.
So a total of 8 units.
8 units, and one of the units was in the carriage house.
And since '01, however, it's just been the 6.
Well, recently, we received a permit to renovate the existing building for 6 units. We thought we would be grandfathered in because of the previous approval and not need to come to the board for a parking variance. They sent us to the board for a parking variance. They took over the building and they're using it for 6 units. We want to use the existing 7th unit, which is permitted by zoning, and ask for the parking variance. It's impractical to put on the property. If you come off of Elgin to put a parking lot, you're at the front of the building, you're at the front of the property, and you would remove a parking space from the community. Now you can park along the whole frontage on Elgin. We also sent a picture. Elgin's a pretty wide street in and of itself. There was no parking issue when I took the picture at 3 o'clock in the afternoon. Admittedly, that's not in the evening. I think
You don't have a parking problem.
Hold on. I don't want to turn. Your contention is for the number of units, total units that you're trying to establish now, which is 7 dwelling units, 1 being in the carriage house, there have always been that many units being
Yes.
utilized.
Yes, if not more. At one point, there were 9 units. And from 57 to 1960. 64, 65, they were changed, they got a permit for 8 dwelling units and 2 rooming units. And this is without any parking on the site whatsoever, just street parking.
So I guess it's your contention that the volume of parking generated by this property would not be any greater than it has been in the
That's right,
past.
that's correct.
Okay.
I mean, we're willing to have the board put a condition on, if they choose to approve it, to limit the carriage house unit to 1 car per tenant. We cannot accept, especially you have existing leases, and people do have more than 1 car. We will be talking to the tenants about respecting where they park. But we can't go backwards, and we don't think the board should have make us deal with the existing units that already have a permit.
Could I add about the parking?
Is it permitted parking?
No, there's no
it's
permit parking.
public. If I may add something, please. If you go toward Elgin Avenue, toward Dennison Street, so there's 4 houses on the entire block, so it's not a very large alley. We know the neighbors there as well. Ms. Camper has told me many times they've never had an issue parking there. So I think simply
There's plenty of parking on the other side of the, of Elgin Avenue toward Dennison, if you're looking on the map.
34110. So it looks like, Ms. Johnson, your home has a driveway.
No.
Oh, your home has a
Ten
driveway, so
has a
you're
driveway.
3410, okay. And you're 3408.
Wait, yeah.
Okay.
And I come home and I'm parking down at the next block when I come home at 3 o'clock in the morning. My daughter's car was stolen. It's parked down the street, can't even see it on my cameras. I mean, unfortunately, it was a Hyundai, but still, they stole it and couldn't pick it up on the camera because it was out of view.
So, I mean, as it is, you can't, certainly, you can't guarantee that you can park in front of your house when you get there. But nobody can if it's public parking, right?
So the challenge with a variance like this is that big picture, your concerns aside, right? Big picture, you're adding a resident that they're willing to limit to one car. So minus visitors or anything else like that, and I understand. I think what I'm hearing is that the challenge is with existing residents and existing property manager not coordinating with the neighbors and making sure that the relationships that you had with the former tenants, we can repair those. Would you be satisfied with working with the current property owner to figure out?
Like I said, I don't have, I'm the least person to have the
'Cause
issue
you have
in
the
everybody in my
driveway.
neighborhood. But my biggest issue comes from parking in front of my car, parking in front of my
in the
driveway.
Yeah.
Now, I'm trying not to be a jerk and have their cars towed. And I've spoken, and I understand how they feel. It's about, I don't have a problem as long as I say it's a respect issue with me.
Yeah.
If I can get the respect from him, because I shouldn't have to talk to his tenants. He has to talk to his tenants.
Sure.
I'm not getting anything out of it but a problem.
So,
So what I'm saying is, if you can tell your tenants 2 cars per property, try to respect everybody else's. I ain't saying they're gonna have to, because it's, like I say, it's Thanksgiving, people have parties, whatever. You're gonna park. And I can understand that, like, people in our neighborhood have parties, and they'll come and say, hey, you don't mind us having extra? Hey, don't mind, I'll park out back so y'all can have the extra parking spaces. So it's respect, and that's what we're saying as a close-knit neighborhood. We're trying to keep our neighborhood respectful. I understood what you said, but as a renter and a buyer, 2 different ideas. When they're in our neighborhood, when I say they, people that are renting, they're not gonna take the same value that I take in my neighborhood, nor they're gonna take care of the people in the neighborhood like I would, because they're not there permanently. I am. Hopefully, I'm there till to throw me in the dirt. But to make sense of it, out of respect, he can control that, because, like I said again, I'm into the same business that they're in, and I also have a brother that's doing the same thing that they're doing, and he put those things on his lease. Whereas though it doesn't mess with the people in the neighborhood, because him being a investor, he has to know his neighborhood, whereas though he can get the okays to do wherever he want to go at, not just bully his way in the neighborhood, which I felt as though they were bullied into the neighborhood and the people down the street were bullied into the neighborhood because everybody popped up. The only person.
I don't.
No, I'm not. I know where you're going. I'm just saying out of respect.
Oh, sure. Okay.
Out of respect.
Okay.
And I respect, and like I said, I respected it. But out of respect, that's my whole problem.
Right. Among the things that you could do with your current tenants to assist in alleviating these issues, what would they be?
So I think immediate comes to mind is inviting them to a community meeting with you folks, because I don't think you know them, and I think that would be helpful so you get to know who the folks
maybe
are.
know as much as they want to know, which is that they are disrespectful with
I've
regard
been
to their
cursed
parking.
out before for parking too close to somebody's car. And I'm like, well, if you know how to park, you should be able to get in and out. The next day I come outside and they got my car sandwiched in, and I mean, I got about this much room in between my car. So I had to walk my son to school.
And so it's these are the things you deal with, and the last thing you need is another vehicle to have the same challenges.
Right.
To fight through that. And you've indicated there's additional parking around, may require some other folks to park further away, but in terms of those kinds of behaviors.
I think we could have a community meeting with the House and I'm happy to do that. Again, I just learned about these last week, and I've indicated that many times, folks, and I think they're aware of that. I'm happy to work with them, absolutely. Okay.
All right, because it sounds like in terms of what the additional parking would be, by virtue of the additional unit, which is what's being requested, over the last many years, there's been that much parking already, it seems. Because there's no limit to your property. There's no limit to, I guess, anybody else's.
Can I say one thing?
Sure.
I know we're going back to 1956.
Well, no, I'm not.
Oh, no, okay, you weren't? Okay.
I'm not.
I thought you were going to.
Because if we have 8
vehicles,
units.
everybody didn't have a car back then, so parking probably wasn't a main issue.
Sure, but since 2001, where you've had, if we're talking about total units.
Okay.
There's been at least that number of people around vehicles.
But more than likely, most of those, well, now I'm gonna say, 4 people were in the apartments during the time I'm here.
Yes, sir.
Most of the vacants were revolving doors, in and out, in and out. Even the little carriage house was being used also. And I think her sister or somebody lived in there. So it was being used, but again, like I said, there weren't a lot of cars there. Most people were either transit people or somebody came and picked them up. It wasn't a parking issue. And the people that did have a car, they parked right there, right in front of the apartment building, which we could park there too, but we don't. I have kids that can park over. I make them park in the alley so the people in the apartments can have places to stay.
Okay. For how long has parking been an issue?
Since that apartment opened up.
Since they opened up that apartment. It's been a mess. Even the house next door to your property, it's two people, 2 different cars that will pull up in front of the house next to yours opposed to pulling up in front of your house and there's spaces available. He was here earlier, Mr. Brown was here, he has a 90-year-old mother and he's gotta walk her down the street.
To get out.
Because we trying to get her in the driveway. He can't even step up on the sidewalk and it's hard for her, you know, it's really hard. And the space is there, they just stop right at his door. Like, I don't know why, but they stop right at his door and the whole street could be clear, and them 2 blue cars, they sit right there.
Yeah, it sounds like an education process or re-education process for folks who are there.
So I think the good news is that by coming, you're able to get with the property owner, address these issues face to face. The thing that I want to make clear is that there's a difference between reconciling community challenges and zoning code. And so I really do appreciate when people use this forum to build relationships and try to figure out solutions to problems. And I would just encourage you, you mentioned that you had in the past with residents good relationships with tenants. So I would hope that the current property owner can course correct and restore that trust with the tenants. But I just want to be helpful in that we can be sympathetic and we can all understand. I live in the city too, and I can't always park near my house. I usually have to park a block away. So I am sympathetic. But today we have to look at the zoning code and sort of what is allowable by right. And so I think the concession they made to register a single vehicle to a new unit is not required by law, but something it sounds like the property owner is willing to do to address some of the concerns. So I just wanted to point that out so that we understand what is possible within the purpose of this meeting today versus what we have authority and don't have authority over.
Anything else, Ms. Merritt?
Just to reiterate, we hope we can reestablish the use in the carriage house rather than leave it vacant. We will convene a meeting. We have a very good relationship with the president of Mount Holly Association. She called us today about this and indicated they were not sending a letter either in support or in opposition, but there would be neighbors that we could follow up with, which we will do. And we will talk to the tenants in the existing building and advise them and have the neighbors with us to say, here's what you're doing wrong. You're blocking my driveway, you're parking too close to my car. That's, it's all I think we can do. And I don't know, there may be community people parking in front of our building, I don't know. But it's a wide street, there's plenty of parking. Certainly I'm parking on Garrison. That's going to be more convenient to the carriage house than parking on Elgin and walking around the block.
Okay. All right. Any questions for? Thank you, folks.
Thank you.
Appreciate it. Any appetite for using a variance?
Just have her text me first.
I
don't know the number.
I can do it. I can do it.
No, I don't think you do, but I would just say.
Turn your mic on.
Last one. I'm new, so I want to be respectful of not letting my jibber jabber.
That's all right. You're welcome.
Similar to one of the cases we heard today where we said, your letter will go out on this date. Can you provide the standard operating procedures? I would just ask that the property owner furnish a lease for the carriage house that includes a provision for the single car. And then if you send that to Ms. Witt prior to the issuance of your letter for the variance, that would satisfy me in terms of granting the variance. But of course, I defer
No, I
to you all.
think I'm inclined to say yes. It's been a lot of people. I don't know how many parkers or folks with vehicles have been there, but certainly the ability for lots of people to be there for the last several years. I think he otherwise satisfies the elements of variance. Likely to be
Yeah, I'd be a yes on it too. And I understand the area. Got a friend that lives around there, right? And they live over on Mondawmin, but people who live on Elamont and have these big beautiful houses that you have to walk up all these steps to get to, they all have backdoor entrances, so they park on Mondawmin and block the people who live there in order to cut up the alley and go in the house, without having to go walk up their front steps. So it's a big problem in the area, but I think the problem that they have is that in each one of these apartments, they may have 3 people and 3 cars. Everybody's got their own car. That's what really tears up parking.
And it's a small block.
It's a small
I
block.
mean, that's the challenge. And so if
And the bike boys are up that way right now. They're
Yeah.
putting in the bike lane. They took Gwynns Falls Parkway down to 1 lane.
Yeah, thanks for that.
Yeah.
I'm a yes. I'm a yes with the condition that there be the lease clause.
Yeah, with the documentation to go before the approval letter comes out, I'm a yes.
Could we just uniqueness and practical difficulty, you don't have to go through the rest of it, but just make findings on those 2 things?
Yeah, it's a large property. I think grading doesn't allow for parking availability on site, and there would be some significant cost, I think, associated with making parking available that's not otherwise there for street parking. So I think it's unique and practically difficult to provide any additional parking there than what's on the street. And so with regard to the others, I think they all apply as well. So I mean, yes, with the condition, it's indicated that they provide a lease confirming the limitation to 1 vehicle for the new unit. And I'm frankly satisfied with the owner's at least statement, intent to talk with the tenants and to help alleviate that situation. I think it can be much improved if they do that. So I'm a yes.
All right.
I'm also a yes for those reasons.
I'm a yes.
I'm a yes. And Mr. Barry, will you connect with the neighbor that is having difficulty with the elderly relative and make sure that they understand that if they qualify, they can apply for a handicap street space? They just probably don't know that process, and I know that you can probably assist them. Yeah. Thank you. I'm a yes.
Great, thanks, everybody.
Thank you all.
Happy holidays. See you in a month.
So proposed calendar